Initial,
Then
initial.
Then why that prayer was made that court should direct?
My lord, they probably, my lord, what happened is CID, my lord, has been entrusted with the investigation or inquiry by this honorable court, my lord. CID may not be the
Now,
authority.
only thing, AAG, only thing I want to know is there is a finding in the report that one IO was derelict, negligent in the holding of the investigation. Whether any departmental proceedings has been initiated against that derelict IO.
Lord, what happened is, my lord, there was a direction to hold inquiry, my lord, pursuant to the orders of this honorable court.
No, that is separate.
CID may not be the authority to initiate the proceedings. That is the technical.
Not necessary. He is also a very senior officer. Yes. He should correspond with the competent authorities, not seeking time and thereby allowing the time to lapse. Once 4 years is elapsed, the jurisdiction will be lost for the government to initiate any proceeding. And this report of 2019, it is filed now. So even court cannot do anything. This is what is known as passing the buck. So please furnish the name. If articles of charges have been issued within the time against that derelict, because you say he is derelict against the IO, you please furnish that. Otherwise, furnish the name. Tomorrow you must furnish the name so that he can explain what he has done. You heard it, Mr. AAG. Yes, Madheshwaran, you understand what I am telling. See, some, I think, I don't know what has happened in the MVC. The court apparently had given a finding that a false claim could be sustained because of the fraud played in the holding of investigation. So, therefore, learned Director General of Police in his report says the IO was derelict. You know dereliction. So, derelict. If that is so, inquiry should be held against him. And since he retired in the year 2017, when he submitted the report in 2019, he said 4 years' time is available. That is correct also, 214. 2 more years were remaining. He, instead of corresponding with the DG IGP for taking appropriate steps and drawing his attention to that, or drawing the attention of the competent authority who could have initiated action, he wastes his time in writing to the court. Court is not disciplinary authority. Please listen. So he should explain why he did that. Not necessary. You give the name. Learned AGA has not furnished the name of the Director General of Police who had signed the report. Full stop. Therefore, he is given 4 days time to do so and comply the order of this court. List on next week. Don't do this. You must furnish. There is no explanation for this. The only explanation who can give is the concerned officer who submitted the report.
Number 2, Pramod R.
Registry to put up postal tracking report regarding service of notice issued to
17th, 21st.
Houda. He order agide 17th. Iಷ್ಟು put up ಮಾಡಿದ್ದೀವಿ. List after 2 weeks. The next to know list after 2 weeks.
4, Pradeep.
You want 2 weeks time? The 2 weeks time granted as paid for. Level 4.1. A memo accepted, notice to R1 is dispensed as paid for. Mr. Pradeep, this 293 days delay can be controlled. Heard on IA number 1 of 2016, filed seeking condonation of delay of 293 days in preparing the appeal. Delay condoned, subject to denial of interest for the period of 293 days. Admit TCR.
5. Rajgopal.
ಏನಾಗಿದೆ
Oriental.
ಇದು ಓರಿಯೆಂಟಲ್ ಕೊಡಿ ಲಿಸ್ಟ್ ಕೊಡಿ AM Vintage is directed to take notice for the appellant as it is informed that Sri Rajagopalan R has passed away. The memo of retirement is accepted. Name of Sri S.V. Prakash to be deleted. ಅದು ditto ಕೆಳಗಿಂದಲೂ ರಾಜಗೋಪಾಲನ್ ಆರ್ ಇದೇನು ಅಡ್ಮಿಟ್ ಡಿಲೇ ಏನಿಲ್ಲ ಅಲ್ಲ ಬೋತ್ ಅಡ್ಮಿಟ್ TCR ಅದು ಎರಡು 5 and 5.1.
in this case, paper applying malad in first case malad.
ಇದೇನಪ್ಪ ಇದು CDPO MSPJ ಅಂದ್ರೆ
Malad in this case, the appellant is working in the dispute between the appellant is working the Anganwadi teacher malad.
ಏನಿದು ಮೋಟರ್ ವೆಹಿಕಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸಾ ಬೇರೆ ಕೇಸಾ?
ಇಲ್ಲ motor vehicle accident case only. They are claiming the compensation malad. The appellant working as a coolie.
ಗವರ್ಮೆಂಟ್ ಹೋದ್ರೆ ಅವರು perused the order dated 15/9/2018. The authorities who have been directed to furnish certain information have not complied with the earlier with the order referred to above. Learned HCGP is directed to secure the information and furnish the same to this court within 2 weeks. A copy of the order passed by this court on 15/9/2018 and today shall be furnished to the learned DGP, learned CGP by AGA, Sri Mahadeshwaran, forthwith for doing the needful. Which matter, madam? ಅದೇ ಯಾರು ಒಂದರಲ್ಲಿ ಏನೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಎರಡರಲ್ಲೂ that's why that is why they are seeking information. It's alla
I appear for the appellant, my lord.
2
In
weeks.
this case, the appeal doesn't survive, my lord. My lord, one submission to me. To ಮತ್ತೆ ಇನ್ನೊಂದು appeal, connected appeal post ಆಗಿದೆ. It doesn't survive, my lord. In view of this, Mukundev, principles laid down in Mukundev case, my lord.
Learned counsel for the appellant, Srimati Harini Shivananda, submits that these two appeals will not survive for consideration in view of the decision of the Honorable Supreme Court in Mukund Devangan, put citation for it. So the said submission is placed on record, and accordingly the appeal is dismissed. Appeal is dismissed. Appeal is dismissed. When I amounted
deposit.
The amounts in deposit shall be transmitted to the learned MACT forthwith along with the record. Yes, madam, done.
I appear for the appellant in the matter, my lords. In the last date, my lords, the lordships had directed me to make the deposit within 1 week. Peremptory order ittu, hagagi dismissal anta bandide. I immediately wrote to the insurance company and found out the entire award amount has been deposited before the tribunal. So, modification of the award, I am filing an IA today itself.
ಯಾವ್ದಕ್ಕೆ?
ಅಲ್ಲ, ಈಗ ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಡೆಪಾಸಿಟ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಇದೆ. Entire amount has been.
ನೀವು ಅಲ್ಲಿ ಮಾಡಿದ್ದೀರಲ್ಲ, ಅಲ್ಲಿ ಮಾಡಿದ್ದೀರಿ. Learned counsel Shri Anup Sitaram submits that the entire award amount has been deposited before the learned MACT.
ಹೌದು.
ಯಾವಾಗ?
2018 ಸರ್, ಸೆಪ್ಟೆಂಬರ್ 2018.
ಡೇಟ್ ಹೇಳಿ.
IA ಮಾಡಿ ಕಳಿಸಿದೆ ನಾನು. ಡೇಟ್ ಇಲ್ಲ ಸರ್.
ಏನ್ರಿ ನಿಮ್ಗೆ ಟೈಮ್ ಕೊಟ್ರು ಇದೇ ಮಾಡ್ತೀರಿ?
ಐಎನ್ಎಲ್ ಬರ್ದಿ ಕಳಿಸ್ಬಿಟ್ಟೆ ನಾನು ಐಎನ ಫೈಲಿಂಗ್, ಅದಕ್ಕೋಸ್ಕರ.
ನಿಮ್ ಕಂಪ್ಯೂಟರ್ ನಲ್ಲಿ ಕಾಣಿಸೋದಿಲ್ವಾ ಇವೆಲ್ಲ? ಯು ಶುಡ್ ಡೂ ಸಮ್ ಕ್ವಿಕ್ ಥಿಂಕಿಂಗ್. ನೀವು ಕಂಪ್ಯೂಟರ್ ನಲ್ಲೆಲ್ಲ ಮಾಡೋದು?
ಹೌದು ಸರ್.
ಅದ್ ಮಾಡಿದ್ರಿ, ಕಂಪ್ಯೂಟರ್ ಓಪನ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗೋದಿಲ್ವಾ?
ಗೊತ್ತಾಯ್ತು.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ತೀರಿ? ಮಾಡೋದಲ್ವಾ ನಾನು?
ಸರಿ.
I'll give you 5 minutes time. I'll come back. You give me the date.
Please, madam.
Memo hakidira. You are Chetan B. Learned counsel Shri Chetan B for the appellant files a memo seeking dispensation of notice to R1. Memo is accepted. Notice to R1 is dispensed with. I'll come back. This is passed over. Please open the computer.
Please, madam.
2 weeks time granted. The call for delay. First in the another delay. 7184 nalli delay. I admit this. 2 weeks time. Idralli 91 days. I condone. Heard on IA number 1 of 2018, filed seeking condonation of delay of 91 days in preparing the appeal for the reasons stated in the affidavit. Delay of 91 days is condoned. Full stop. Admit is here. 2 weeks time granted as paid for. Delay ilva? Admit is here.
Your Lordship, the company appeal, the first one, 2727 of 2018, does not survive in view of Mukund Devangan's judgment, Your Lordship. We had questioned that he was possessing non-transport, but
Senate counsel for the appellant.
in 270.
You are saying 2730, and what about
2730 only, no, that is 2727 does not survive, Your Lordship. And 2728 also, Your Lordship, here they have, kind of 40% of the income of the, that is also does not survive, Your Lordship. 2729, in that, just a second. 2729 also, it does not survive, Your Lordship.
ಅಂದ್ರೆ 3 ಒಂದು ಮಾತ್ರ ಉಳಿತದ?
2730 ನಲ್ಲಿ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಲಾಸ್ ಆಫ್ ಎಕ್ಸ್ಪೆಕ್ಟೆನ್ಸಿ ಆಫ್ ಲೈಫ್ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
ಅವರು
50,000 towards loss of expectancy of life.
Okay, first this 11.1, 11.2 and 11.3 are covered by Mukund Devangan.
Yes, your lordship. 27.
So they don't survive for
2008. Yes, your lordship. MFA 2730 of 2018, your lordship. There only 1 point remains.
One minute, madam. One minute. Kindly wait. So, except 2730/2008, the other 3 appeals are covered by Mukund Devangan,
yes,
and they don't survive for consideration.
Yes,
wait then.
Yes, sir.
11.1, 2 and 3. Learned counsel for the appellant submits that the above appeal does not survive for consideration in view of the decision of the Honorable Supreme Court in Mukund Devangan. That's new citation full stop. Accordingly, the appeal is placing the above submission on record. Appeal is dismissed. That's done. Amur 11 and 3. ಇದರಲ್ಲಿ ಹಾಗಿದ್ರೆ ನೋಟಿಸ್ ಆಗ್ಬೇಕಲ್ಲ. If you need that portion to be interfered, then R1 and R2 have to be served. You have to take
one week time may kindly be given, your lordship. I'll just have a word with the company because 50,000 award ಮಾಡಿದ್ದಾರೆ. So if there are any chances of ಇದು ಅಂತಂದ್ರೆ I may be withdrawing also after having a word with the company. Otherwise, I'll take steps, your lordship, for respond 1 and 2.
2730/2008. Learned counsel for the appellant prays for a week's time. Accordingly, released next week.
Obliged, your lordship.
12, Shivkumar Pay.
Learned counsel for the appellant submits that he has taken necessary steps for service of notice to the respondent today. He will delay the appeal. Okay. Admit notice DCR. Admit. Okay.
That is, Bagan aap ke dilaya?
Lordship, 3 days time may be given to take steps.
Oh, you have not taken, what is the order last time?
I have taken in 2019, 2019,
Madam,
I have taken steps.
Please bear with me. We are not going behind the last order. What was the last order? The dispensary in terms of memo 5. There is 4 weeks time is granted to take steps in respect 1, 2 and 4, failing which the appeal stand dismissed. You are not interested. This is 16/11/2019. When did you take?
I will take steps within 2 days.
In spite of the order which is in peremptory nature, in spite of the order which is peremptory in nature, dated 6/11/2019, appellant has not chosen to take steps. Even today, learned counsel for the appellant wants some more time for taking steps. ಏನಿದು ಕುಡಿಲಿ ಎಷ್ಟು ಏನಾಗಿದೆ ಇಂಜುರಿಗೆ? Because we don't even have time to consider the appeals where parties are very serious, earnest, and we should not show leniency to people who are non-serious, non-earnest.
I will take steps today itself.
We have 16,000 appeals, so we should give time only to those who are earnest and serious. This I have been telling day in and day out. I have been emphasizing. Still you do this in spite of 3 years. You don't care to take steps. What is the appeal about?
Your Lordship, it is a case of injury.
What kind of injury? What is the error in the appeal? What is the error in the appeal?
Lordship,
Why
I
should
will just,
No. For everything you want time.
I just pass over. I will come at
No.
2:30.
Not necessary. I told you this, our time is meant for earnest people. Not this kind of non-serious. Learned MACT has considered everything. Appeal, therefore, appeal dismissed for non-prosecution. Next.
14, R. Sharma.
Appeal was filed with the delay of 271 days. Sorry. Appeal nalli delay illaga. The appeal was dismissed. Not prosecution. Appeal was dismissed on 15/10/2019. For non-compliance of his objection. This restoration application is filed after a delay of 271 days. The records further disclose that appeal itself was filed with a delay of
546 days.
546 days. Hence, the applications are dismissed for non-prosecution. First, the learned counsel for the appellant is absent, no representation. Applications are dismissed for non-prosecution. Consign the record. Learned counsel for the appellant is absent, no representation. Either no appeal delay. Applications are dismissed for non-prosecution. Consign the record. Just open. I dismiss for non-prosecution. Next, 16. Memo accepted. Notice to R5 dispensed with. Mr. Anup.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಮೆಮೊ ಇವತ್ತು ಫೈಲ್ ಆಗಿದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ 29/12/2018 ಗೆ ಪೇಮೆಂಟ್ ಆಗಿದೆ ಸಿಟಿ ಮುಂದೆ
MACT ಮುಂದೆನಾ?
ಹೌದು, ಇವತ್ತು ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Learned counsel for the appellant submits that he has today filed a memo before the registry stating that entire amount of 50%.
50% of the amount.
That 50% of the award amount has been deposited before the learned MACT on
29/12/2018.
Full stop. The memo is accepted. Delay ಏನಾದ್ರೂ ಇದೆಯಾ? ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ.
Admit TCR. Admit notice. ಅದರಲ್ಲೂ ಡಿಲೇ ಏನಿಲ್ಲ ಅಲ್ಲ? Whether you have deposited the 20, have you deposited? Why from 2018 you require so much time? Learned counsel for the appellant prays for 2 days time for complying with the deposit of the award amount as directed on 10/10/2019. Similarly, steps also to be taken. 2 days time granted as paid for. Memo accepted. Notice to R1 dispensed with. I see.
For the appellant, madam.
Mr. B. Pradeep is directed to take notice for respondent number 2 Sri Suresh M. Lathur to furnish one set of appeal papers to Sri P. Pradeep. Memo accepted. Notice to R1 dispensed with. Admit TCR. Delay Lala.
19. Sripati Shastri.
Memo accepted. Notice to R1 dispensed with. 99 days. K.N. Srinivasa. Heard on IA number 1 of 2018 for the reason stated in the affidavit. Delay of 99 days in preparing the appeal is known. Appeal admitted. TCR.
Hearing number 20. MP Rajka.
Appear for appellant, my lord.
PB Raju.
ಮಹೇಶ್ ಸಾಹೇಬ್ರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
for respondent.
Name of Shri PB Raju for R1 to be deleted. Mahesh, that 136 by denying interest I will condone.
Yes, my lord.
Heard on IA number 1 of 2017 filed for condonation of delay of 136 days in preparing the appeal for the reason stated in the affidavit. Delay of 136 days is condoned subject to denial of interest for 136 days.
My appeal, my lord.
Lord, in this matter, my lord, there is one more connected appeal, my lord. One more 49-48 of 2017, my lord.
I admit this one. One more ಇನ್ನು ಈ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇಲ್ವಾ?
ಇಲ್ಲ, ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ಸರ್ ಇವತ್ತು.
ಆಯ್ತು, ಪೋಸ್ಟ್ along with a number.
ಹೇಳಿ ಸರ್, ಇನ್ನೊಂದು ಸರಿ.
MFA 49-48 of 2017.
21.
I appear for appellant, my lord.
ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಮತ್ತೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಹೇಗೆ?
Earlier, my lord, the substituted service was allowed on 29/1/2020. The draft, my lord, was not intimated. That's why, my lord.
ಆಯ್ತು, ಈಗ ಯಾವಾಗ ಮಾಡ್ತೀರಿ? ಯಾವಾಗ?
ಅಲ್ಲ, ಇವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ, ಅದು ಅಲೋ ಆಗಬೇಕು.
ಆಯ್ತು. Heard on IA number 1 of 2020 filed for issue of notice to R2 by way of paper publication. ಯಾವ ಪೇಪರು?
This is
ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ. ಎಲ್ಲಿದು?
ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ,
ರಾಮನಗರನ ಇದೆಯಾ? ಅದು ರಾಮನಗರ ಎಡಿಷನ್.
ರಾಮನಗರ ಎಡಿಷನ್.
ರಾಮನಗರ ಎಡಿಷನ್ ಇದೆಯೇನ್ರಿ ಸಂಯುಕ್ತ ಕರ್ನಾಟಕಕ್ಕೆ?
ಇಲ್ಲ, ಅದೇನಾಗ್ತದೆ, ಒಂದು ಪೇಜು ಅಲ್ಲಿ ಇರುತ್ತೆ, ರಾಮನಗರದ್ದು ಇರುತ್ತೆ. ಮೈನ್ ಪೇಪರ್ ಅಲ್ಲೇ ಒಂದು ಪೇಜು ರಾಮನಗರ ಇರುತ್ತೆ.
ಆಯ್ತು, ಅದಕ್ಕೆ ರಾಮನಗರ ಎಡಿಷನ್ ಅಂತ ಹೇಳೋದಾ?
ಅಲ್ಲ,
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಕೆಲವು ಪೇಪರ್ಗಳಿಗೆ ಹಾಗೆ ಇರುವುದಿಲ್ಲ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ವೈಸ್. ಅದಕ್ಕೆ ಕೇಳಿದೆ, ನಾ ಏನು ಆರ್ಡರ್ ಮಾಡ್ಲಿ?
ಅಲ್ಲ,
ಸಂಯುಕ್ತ
ಸರ್ಕ್ಯುಲೇಟೆಡ್ ಇನ್ ರಾಮನಗರ್
ಇಂಥವೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ನಾನು ಮತ್ತೆ ಸರ್ಕ್ಯುಲೇಷನ್ ಯಾರು ಮಾಡೋದು?
ಅಲ್ಲಲ್ಲ, ಅದಿದೆ, ಅವ್ರು ಮಾಡಿದ್ದಾರೆ. ಏನಾಗುತ್ತೆ, ಒಂದು ಪೇಜ್ ಮಾತ್ರ ರಾಮನಗರ ನ್ಯೂಸ್ ಇರುತ್ತೆ, ಉಳ್ಕಿದೆಲ್ಲ ಬೇರೆ ಇರುತ್ತೆ.
ಏನ್ ಬರ್ತಿದ್ದಾರೆ ಅವರು? ನಾವು ಅದೇ ಆರ್ಡರ್ ಮಾಡೋಣ ಎಲ್ಲ. ಕೊನೆಗೆ ಅವರು ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ನಿಮ್ಮ ಡೈರೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ ಯಾರು ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡೋದು ಅಂತ ಕೇಳಿದ್ರೆ ಏನ್ ಮಾಡೋಣ?
29/1/2020
ಕರ್ನಾಟಕ ಆಫ್ ರಾಮನಗರ ಎಡಿಷನ್.
ಅದೇ ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ ಆಸ್ ಫ್ರೀಡ್ ಫಾರ್.
ಪ್ಲೀಸ್.
ಆಮೇಲೆ ಡೇಟ್ಸ್ ನೀವು ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ.
ಆಯ್ತು.
IA 1 of 20 allowed.
ಪ್ಲೀಸ್.
ಅರುಣ್ ಕುಮಾರ್ ಡಿಎಂ.
ಇದು ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ? ಇದು 21 ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಅಡ್ಮಿಟ್ TCR. ನಿಮ್ದೇನು? ಆಯ್ತು, ನೋಟಿಸ್ ಆಗ್ಲಿ.
Please, my lord, I appear for the appellant to lordship.
Notice.
My lord, sorry, my lord, I have information by my colleague, my lord, the matter is settled before the Lok Adalat, my lord. Therefore, only the reason before your lordship to restore and because does not survive, my lord, because the matter is settled before the Lok Adalat, my lord.
Can I record that it is settled before Lok Adalat?
Please, my lord.
So therefore, this has to be dismissed, is it?
Please, my lord.
learned
ಅಲ್ಲ
counsel.
ಡಿಸ್ಮಿಸ್ ಅಂತ ಅಂದ್ರೆ ಇದಾಗುತ್ತೆ, ಸೆಟಲ್ ಬಿಫೋರ್ ದಿ ಲೋಕ್ ಅದಾಲತ್ ಅಂದ್ರೆ ನಾನು ಸಬ್ಮಿಷನ್ ತಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರು ಲಾರ್ಡ್ಶಿಪ್.
ಅಂದ್ರೆ ಮತ್ತೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕಾ ಏನ್ ಮಾಡ್ಬೇಕು?
ಹೌದು ಡಿಸ್ಪೋಸ್ ಲಾರ್ಡ್ಶಿಪ್. Because dismiss ಅಂದ್ರೆ the order is settlement before the
ಆಯ್ತು ಸರ್, ಆಯ್ತು.
Please madam.
ತಾವು ಶ್ರೀ ಜಗದೀಶ್ ಗೌಡ ಪಾಟೀಲ?
Please madam. Myself is Jagdish Gaud Patil madam.
Shri Jagdish Gaud Patil, learned counsel for the appellant, submits that the matter is disputed, matter is settled before the Lok Adalat, full stop. The above submission is placed on record. The order dated 4/11/2019 is recalled. IA number 1 and 2 of 2021 are allowed. Appeal disposed of.
Please madam.
As settled before Lok Adalat. Appeal disposed of.
Please madam.
For the Lok Adalat.
I appear on behalf of A. Ramakrishna, my lord. The first respondent expired. Notice has to go.
Notice on IA number 1, 2, and 3 of 2021.
My lord, respondent number 2 here, my lord. My application relating to release the depositment amount, my lord. My lord,
You file, Mr. Ramakrishna.
Yes, my lord.
You have any objection for releasing the amount?
Because other LRs also on record, the notice has to go. They have to come on record.
My lord, here, my lord, this is 2015.
Sir, then Mr. Counsel, you file proper application so that it can be heard whether a release order has to be made or not. When there is some dispute, better file an application, not memo.
My share, my lord, my share relating to my share.
Memo is rejected. It is open to the learned counsel to file proper application seeking release of the deposit amount.
Much, my lord.
I admit delay in Ilala. Yeah. Memo reporting depositing of the cost amount of ₹5,000 is accepted. First deposit ಮಾಡಿದ್ದೀವಿ. This is claimant's appeal or owner appeal? You appear for claimant. Claimant. You are Sri H.A. Ananda. Where is Govardhan? Owner? List next week for hearing on IA 1 of 2021. For consideration of IA number 1 of 2021. Sri Govardhan, yes, for the, sorry, learned counsel for the appellant is absent, no representation. Next week andre date ಬರುತ್ತೆ, ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡೆ ಬರ್ತಿದ್ದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಇರುತ್ತೆ, ಬರುತ್ತೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಯು ಕೈಂಡ್ಲಿ ಚೆಕ್ಅಪ್ ಇನ್ ದಿ Mr. Pradeep, heard on IA number 1 of 2018, claimant's appeal. For the reasons stated in the affidavit, delay of 302 days in preferring the appeal is condoned, subject to denial of interest for 302 days. Admit TCR.
Admission.
Steps ತಗೊಳ್ಬೇಕು appellant. What is the order dated 10/11/22? 10/11/22? What was the order? So you can accept that. Memo filed by, who filed? You filed? Memo filed by learned counsel Sri Suresh M. Lathura. Suresh M. Lathur is accepted. R2. R2 will be treated as LR of R1 also. R2 is treated as legal representative of R1. So ಆಮೇಲೆ ಏನಾದ್ರು R3 ಒಂದು ನೋಟಿಸ್ ಆಗ್ಬೇಕಲ್ಲ. 2 weeks time, 2 days, 2 weeks time granted for taking steps to R3. Delay ಏನಾದ್ರು ಇದೆಯಾ ಇದರಲ್ಲಿ? Delay ಇದೆಯಾ ಮೇಡಮ್? ಇದು 6842 of 2018.
ಹೌದು ಸರ್, 55 days
ಇದೆಯಾ? ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದೇನಮ್ಮ? 1 of 2018.
1 of 18.
Heard on IA number 1 of 2018, filed for condonation of delay of restored days. 55 days. For the reason stated in the affidavit, delay of 55 days in filing the appeal is controlled. Admit TCR. That's 2 weeks. Then, madam. ಅಲ್ಲಮ್ಮ, ಇದರಲ್ಲಿ ನಿಮ್ಮ ಅಪೆಲೆಂಟ್ ನಲ್ಲಿ ಒಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರಾ? ಅಲ್ಲಮ್ಮ, ಫಸ್ಟ್ ಅದಕ್ಕೆ ಸ್ಟೆಪ್ ಆಗ್ಬೇಕಲ್ಲ. ಅಪೆಲೆಂಟ್ ನಲ್ಲಿ ಒಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಕ್ಕೆ ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕಲ್ಲ.
ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್ 50%. ಇವಾಗ ಒಂದು ಸತ್ತೋಗಿದಾರಲ್ಲ, 2 ಎಲ್ಲಾರ ಟ್ರೀಟ್ ಆಯ್ತು, ಅದಕ್ಕೆ ಮಾಡಿ.
ಅದರಲ್ಲ, ಇನ್ನೊಂದರಲ್ಲಿ ವೇಟ್ ಮೇಡಮ್. So this was filed in 6842 or which appeal? Heard on IA number 1 of 2020. You can't have objection because heard on IA number 1 of 20. They are husband and wife or husband and wife? Okay. Heard on IA number 1 of 2022. Filed seeking modification of the order dated 10/11/2021. Full stop. Respondent, respondent number 1 husband or wife? Correct, Allah? It is submitted that respondent number 1 is the husband and respondent number 2 is the wife. And the respondent number 1 has passed away. Full stop. The direction in the order dated 10/11/2021 is to the effect that 50% of the award amount deposited before the court shall be released equally between R1 and R2. Since R1 has passed away after passing of the said order, the entire amount in deposit shall be released in favor of R2. ಅಷ್ಟೇ ಅಲ್ಲ, ಅದರಲ್ಲಿ ಇನ್ ನೆಕ್ಸ್ಟ್ ಇಂದಲ್ಲಿ ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕು. ಎಷ್ಟು ಟೈಮು? learned counsel prays for a week's time. Is madam 27.1 weeks time for taking necessary steps. Admit TCR. Notice.
Here for the appellant in this case, my lord, after filing of this application, this honorable court had granted me time to comply with office objections. Accordingly, I have complied, my lord.
Learned ಎಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? ನೋಟಿಸ್ ಹೋಗ್ಲಿಕ್ಕಿದೆ, ಬಟ್ ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಕಂಪ್ಲೈ ಮಾಡಬೇಕು. ಕಂಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ ವಕಾಲತ್ ಹಾಕ್ಬೇಕಾಯ್ತು.
ಆಯ್ತು, ನೋಟಿಸ್ TCR. ಈ ಆಫೀಸ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಆಫೀಸ್ ಒಬ್ಜೆಕ್ಟ್ ಕಂಪ್ಲೈನಾ? ನೋಟಿಸ್ TCR. Mahesh.
For the appellant.
ಇದು ಏನಿದು ಈ IA 2 of 2022 issue of summons?
I am for the respondent, my lord, in this case. Claimants.
For additional evidence.
Who filed this IA 2?
My lord, I filed, my lord, IA 1 and 2.
What do you want summoned?
My lord, we want to, my lord, we have produced the, my lord, certified copy of the deposition of PW2 to file in magistrate court, my lord, in CC number 13,850 of 2017, and also judgment. In support of that, my lord, the witnesses were examined.
1 minute. What do you want summoned by this court? What exactly is you want summoned?
Lord, it is not, my lord, the witnesses to be summoned, my lord.
Witnesses to be summoned here.
Lord, it is a subsequent event, my lord. The last time when the matter was heard by the court.
IA 2 of 2022. Yeah, 2 of 2022.
In view of this, my lord, the matter has to go back. Opportunity to, my lord.
IA number 2 of 2022 is filed by the appellant under Order 16, Rule 1 and 2 of CPC, read with Section 169 of MV Act 1988. The prayer in the application is as follows. The application is required to be considered at the time of hearing the appeal.
Please.
My lord, I have filed my objections also for that eyes.
ಅದು ಆಮೇಲೆ ಈಗ ನಾವು ಯಾವ್ದನ್ನು ಅಂತ ಪೀಸ್ ಮೀಲ್ ಅದು ಇಟ್ ಈಸ್ ಇನ್ ದಿ ನೇಚರ್ ಆಫ್ ಎಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್.
Yes, my lord.
ಅದರಲ್ಲಿ ಹಾಗೆ ಬರೀರಿ. Since the application is in the nature of additional evidence, comma, it is required to be heard along with the main appeal. Permission to withdraw.
Yes.
Mr. Mahesh?
That will not, my lord. It's a fraud case, my lord. That's the reason, my lord.
ಏನು ಫ್ರಾಡ್ ಅಂದ್ರೆ ಏನಾಗಿದೆ?
Totally, my lord, in the light of, my lord, the applications filed by me, producing the, my lord, deposition of the, my lord, witnesses examined before the magistrate and certified copy of the, my lord, order passed by the magistrate and the witness to be summoned, my lord.
What was the order passed? What was the order passed by the learned magistrate?
My lord, there is totally, my lord, different because the witnesses who have been examined before the magistrate, my lord, they have not supported the, my lord, prosecution, and the witnesses examined before the MACT, my lord, have given a contrary evidence before the, my lord, this thing regarding the occurrence of, my lord, involvement of the accident.
In the criminal case, witnesses have turned hostile.
My lord, witness who has been examined, my lord, in the criminal case, later examined in the MACT, my lord, gives a different version.
There they have supported the case of prosecution and totally hostile.
Later, my lord, he was examined in the MACT, he gives a different version as to the occurrence and involvement.
The learned counsel Sri O. Mahesh submits that the witnesses examined before the learned MACT were also examined before the learned JMFC during the trial in respect of
my lord,
my
lord, one submission, my
driver
lord.
of the offending vehicle and the same witnesses have given contradictory versions before the two courts. He submits that the case is one of fraud and therefore the amount in deposit should not be released. Therefore, IA number 1 of 2019 is rejected for the present.
My lord, my one submission, my lord.
Yes.
Insurance company has not examined any witnesses, my lord, in that case. It is first time they are taking that contention in before this honorable court.
He has filed applications. You will have to, face all that. Let us see. Admission.
32 overhead.
I admit. TCR ಬಂದಿದೆಯಾ? Admit. 2.1 also admit. ಎಲ್ಲ admit ಆಯ್ತು. ಯಾವುದಲ್ಲೂ ಡಿಲೇ ಇಲ್ಲ ಅಲ್ಲ? Vijay Kumar, Mr. Vijay Kumar.
Connected matters, my lord. Appeal and counter appeal. 2 vehicles.
Right. 32.5, Mr. Vijay Kumar. 2010ರದ್ದು.
ಅದು ಏನಾಯ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗಿ ಬಂದ್ಬಿಟ್ಟಿದೆ ಕನೆಕ್ಟೆಡ್ ಅಂತ ಡಿಲಿಂಕ್
ಇದಿಷ್ಟು ಕನೆಕ್ಟೆಡ್ ಹೌದಾ?
ಇವೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಇದು R3 ಅಂದ್ರೆ ಯಾರು? ಇವರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆದ್ರ ಇವರು BV ಶಂಕರನಾರಾಯಣ ರಾವ್. Otherwise, I can hear and dispose of today itself. ಈ 2010ರದ್ದು ಇದು.
I am ready, my lord. I am ready.
ನೀವು ready?
There's one more connected matter, my lord, 5633 of 2010, which is before the division bench.
But ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ?
So last time, that's what my lord said, how to whether, if these can be disposed of, it can be disposed of, and that can take its own course. I just bringing it to the notice of this court, that is all.
A decision of, my lord, this court in these cases will be binding on the...
ಇಲ್ಲ ಬೇಡ ಹಾಗೆ ಮಾಡಬಾರ್ದು. ಇರ್ಲಿ ಹಾಗೆ. ಇದು BV ಶಂಕರನಾರಾಯಣ ರಾವ್ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಹೆಸರು ಇದೆ ಅಂದ್ರೆ ನೋಡಿ, ಅವರು ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಆದವ್ರೆ ಅಲ್ವಾ ಇವರು? ಮತ್ತೆ ಅಲ್ಲಿ ಅವರಿಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯಾರಾದ್ರೂ ಆಗ್ಬೇಕಲ್ಲ. Who is R3, Raju, in the first appeal?
Raju is appearing for claimants, my lord.
I am for the claimants in these matters. KSRTC.
Then
who is appearing for APSRTC?
APSRTC.
I am appearing for, my lord, the insurer of the other vehicle.
ಅಂದ್ರೆ ಈ BV ಶಂಕರನಾರಾಯಣ ರಾವ್ ಫಾರ್ R3 ಅಂತ ಇದೆ. ಅದು R3
the insured, sorry. The insured.
ಮತ್ತೆ ಇವರು ನೀವು ಅವ್ರ ಲಯಬಿಲಿಟಿ ಎಲ್ಲ ಕ್ವಶನ್ ಮಾಡ್ತಾರೆ. R3 is also required.
Yes, my lord. Yes, my lord.
The vehicle is covered with Sri Mahesh or insurance company cover ಆಗಿದೆ.
ಅದೇ ಅವ್ರ ಲಯಬಿಲಿಟಿ ಕ್ವಶನ್ ಮಾಡಿದ್ರೆ ಓನರ್
ಮಾಡಿದ್ರೆ ಬೇಕಾಗುತ್ತೆ.
ಮಾಡಿರ್ತಾರೆ ಅವರು.
ಅವ್ರು only quantum ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ.
ಹೌದಾ? Mr. Mahesh, you are questioning only quantum.
Oh, only quantum.
And quantum.
Only quantum.
Negligence and quantum, my lord. 2 vehicles are involved.
Negligence ಆದ್ರೂ ಇನ್ಶೂರ್ಡ್ ಗೆ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ ಸರ್. ಇನ್ಶೂರ್ಡ್ ಗೆ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ.
Coverage is
not disputed. I am in quota number 28, my lord. Just few minutes, my lord. I am in quota number 28.
Mr. Vijay Kumar, this 32.5 ನಿಮ್ದು ಏನೋ ಒಂದು ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬಂದಿದೆ.
My lord, I'll verify from the. I'll get the information from the APSRTC, my lord.
Then
mostly ಮಾಡಿರ್ತಾರೆ. Next week,
I will do one thing for the present. I will admit all the appeals. Anyway, they are very old. They will come for.
ಸ್ವಲ್ಪ ದುಡ್ಡು ಅರ್ಧ ದುಡ್ಡು ಬಂದಿದೆ ಸರ್.
They have received. Then we have deposited.
ಅಂದ್ರೆ ಇದು ಆಟೋಮೆಟಿಕ್ ಬರುತ್ತೆ ಇದು ಹಿಯರಿಂಗ್ ನಲ್ಲೂ.
ಆಗ್ಬೋದು.
I will admit now.
Please,
ನೀವು ಅಷ್ಟರೊಳಗಡೆ ಎಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ. Please inform.
Admit ಮಾಡಿ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಸರ್.
ಮಾಡ್ತೇನೆ. BV ಶಂಕರನಾರಾಯಣ ರಾವ್ ಎಲ್ಲದಲ್ಲೂ ಇದ್ದಾರೆ. ನೀವು
ನಾನು ತಿಳಿಸ್ತೀನಿ ಸುಮ್ಮನೆ ಅವ್ರ ಕೊಲೀಗ್ ಹೇಳ್ತೀನಿ. ಅಲ್ಲಿ ಇನ್ಫಾರ್ಮ್ ಕೊಲೀಗ್.
ವಕಾಲತ್ ಇದೆಯಾ ಮೇಡಮ್?
Please, my lord.
ಬೇರೆ ಯಾರು ಇಲ್ಲ. So Shri BV ಶಂಕರನಾರಾಯಣ ರಾವ್ has been designated as a senior counsel. Stop. All these ಎಲ್ಲ ಅಪೀಲ್ಗಳು ಯಾವ್ದಲ್ಲೂ ಡಿಲೇ ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಏನಿಲ್ಲ.
ಎಲ್ಲಾನು ಅಡ್ಮಿಟ್ ಆಯ್ತಾ? ಲಿಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಫಾರ್ ಹಿಯರಿಂಗ್. ಅಷ್ಟೊಳಗಡೆ ಪ್ಲೀಸ್ ಡೂ ಸಮಥಿಂಗ್ ಅಬೌಟ್ ಶ್ರೀ BV ಶಂಕರನಾರಾಯಣ ರಾವ್.
ಇವತ್ತೇ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ.
Please, my lord.
33 A business
33 and Krishna Swami.
My lords, I am appearing on behalf of Mr. T.M. Venkat Reddy, madam. My lords, my senior counsel is engaged in a different matter, my lord. Pray for some time, madam.
I admit. ಇದರಲ್ಲಿ TCR ಬಂದಿದೆ. ಗೋಪಾಲ ಕೃಷ್ಣ. ಕೃಷ್ಣ ಸ್ವಾಮಿ 34. ಅಲ್ಲ ಇವಾಗಲೇ ಮಾಡ್ಬೋದಲ್ಲ, ಇದು ಹಳೇದು. ಅಡ್ಮಿಟ್ TCR ಇದೆ ಅಡ್ಮಿಟ್.
ಮೈಲಾಡ್ ಇದರಲ್ಲಿ ಸುಗುಣಾರೆಡ್ಡಿ ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು 16ನೇ ಇಸ್ವಿಲಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಐ ಡಿಡ್ ನಾಟ್ ಫೈಂಡ್ ಎನಿ ಕಾಪಿ. ಐ ರಿಕ್ವೆಸ್ಟ್ ಹರ್ ಟು ಸೆಂಡ್ ಮಿ ಎ ಕಾಪಿ. ಮ್ಯಾಟರ್ ಮೇ ಬಿ ಟೇಕನ್ as soon as I will get the copy and may be disposed of.
Admit.
Please,
for
Mylord.
Consideration of ಅದೇನು ನೋಡಿ ಇಲ್ಲಿ ಕೊಡಿ.
ನಾನು ಐ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವಿತ್ಡ್ರಾ.
ಇಲ್ಲಮ್ಮ, ಈ ಬರುತ್ತೆ ಇಮಿಡಿಯೇಟ್. ನೀವು ಅವ್ರಿಗೆ ಏನೋ ಸಮಸ್ಯೆ ಅಂತೆ, ಪೇಪರ್ಸ್ ನೀವು ಒಂದ್ ಸ್ವಲ್ಪ ಕೊಡ್ತೀರಾ ಅವರಿಗೆ?
ಕೊಡ್ತೀನಿ, ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ 2016, ಬಟ್
ಇಲ್ಲ ಅವ್ರ ಪಾಪ ಕೊಟ್ಟಿರ್ಲಿಕ್ಕಿಲ್ಲ ಅಂತ ಹೇಳೋದಿಲ್ಲ. ಈಗ ಏನೋ ಮಿಸ್ಲೇಸ್ ಆಗಿದೆಯೋ ಏನೋ.
ಐ ವಿಲ್ ಸೆಂಡ್ ಥ್ರೂ ಕೊರಿಯರ್ ಮೈಲ.
ಅವ್ರಿಗೆ ಇದು ಸಾಫ್ಟ್ ಕಾಪಿ ಆಗತ್ತಾ ಕೇಳಿ, ಯು ಕ್ಯಾನ್ ಡೂ ದ್ಯಾಟ್ ಆಲ್ಸೋ.
ಕಳಿಸ್ತಾರೆ ಪ್ಲೀಸ್.
ಏನ್ ಬೇಡ, ಇದು ಅಡ್ಮಿಷನ್ ಲಿಸ್ಟ್ ನಲ್ಲೇ ಬರ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅಡ್ಮಿಟ್ TCR ಇದೆ, ಎಲ್ಲ ಅಡ್ಮಿಟ್. ಅಡ್ಮಿಟ್
ಮೈ ಲಾರ್ಡ್ 38.1 ನಲ್ಲಿ ಐ ಆಮ್ ದಿ ಅಪಲೆಂಟ್. ಅದು ಓನರ್ಗೆ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು. ಥರ್ಡ್ ಟೈಮ್ ಬಂದಿದೆ. ದಯವಿಟ್ಟು 1 ವೀಕ್ ಟೈಮ್ ಕೊಟ್ರೆ ತಾವು ನಾನು
ಅಲ್ಲ, ಇದು ಯಾಕೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೇಕು? 1154 ದಿನ ಡಿಲೇ ಇದೆ. 1100
ಏನು ಅಂತಂದ್ರೆ ಸ್ವಾಮಿ, ಅದು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಹಾಕಿ ಅದರದ್ದು ಡಿಲೇ ಮೈಲಾರ್ಡ್. ಐ ವಿಲ್ ಪ್ಲೇಸ್ ಇಟ್ ಬಿಫೋರ್ ದ ರೆಕಾರ್ಡ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
2 weeks time granted as a last chance for taking steps to
ಆಯ್ತು ಸ್ವಾಮಿ.
R2 admit. Admit. ಯಾಕೆಂದ್ರೆ 2010 ಇದೆ. Admit. 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 Admit.
43, my lord. My lord, in serial number 43, my lord. In serial number 43, my lord.
Yes.
In serial number 43, Sri Shaila has, as per on behalf of the insurance company, has filed an appeal, my lord. Sri Shaila has filed an appeal, MFA 6190 of 2014. Therefore, his name may be shown to for respondent number 2, my lord.
Serial number 43 ಅಲ್ಲಿ K. Suresh, name of Sri K. Suresh to be deleted as appearing for R2. Full stop. Sri K. Suresh submits that Sri Shaila has filed wakalat for R2. Name of Sri Shaila, yes sir,
yes.
To be shown as appearing for R2.
My name may be deleted, my lord.
Your name is deleted, sir.
Yes.
Innone connected number ಹೇಳಿ sir.
MFA 6190 of 2014, but that is dismissed for non-prosecution, my lord.
43 admit TCR.
It may be shown in the cause list also that it is dismissed for
non-prosecution. 44 admit.
45 please.
Admit TCR. 45.1 admit.
Final hearing.
Iದೇನಿದು?
Release from part.
Release from part.
Final hearing 47. Maybe
ಈಗ ಸೆಟ್ಲ್ ಆಯ್ತಾ? ಅದೆಲ್ಲ ಈಗ ನೀವಿಲ್ಲ, ಮೇನ್ ಮ್ಯಾಟ್ರ್ ಆರ್ಗಿ ಮಾಡಿ. settle ಆಗಿದೆ ಅಂದ್ರೆ settle ನಾನು I will dispose of on that. ಇವತ್ತು ಅವರೆಲ್ಲಿದ್ದಾರೆ?
ಕೃಷ್ಣಸ್ವಾಮಿ
ಮೊನ್ನೆ ನಾಗರಾಜ ಇದ್ರು, ನೀವೆಲ್ಲಿ?
ಎಸ್ ನಾಗರಾಜ್, ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ?
ಅವ್ರು ಎಲ್ಲಿ ಯಾಕೆ ಬರ್ಲಿಲ್ಲ ಗೊತ್ತಾಗ್ತದೆ. You should accept that. Otherwise, you civil.
Compromise or I go on to the maximum. But that so that I have paid 1 lakh rupees. I have produced the account extract along with the affidavit.
ಇದು 47 ಶ್ರೀ ತಮ್ಮ ಹೆಸರೇನು? ಶ್ರೀ ಜಿ ರವಿಶಂಕರ್ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪೆಲೆಂಟ್ ಅಂದ್ರೆ 47 ನಲ್ಲಿ is present. Shri S Nagaraja for R2 to R4 is absent. List next week. ಏನ್ ಮಾಡೋದಪ್ಪ ನಾನು? ನೀವು ಒಬ್ರು ಬಂದ್ರೆ ಒಬ್ರು ಬರೋದಿಲ್ಲ. I am also tired of this. ಇದು 4 ವಾರದಿಂದ ಇದೇ ತರ ನಡೀತಾ ಇದೆ. ಅಂದ್ರೆ ನನಗೆ ನೀವು ಬರ್ತೀರಿ ಅಂತ ಗೊತ್ತಿದ್ರೆ, ಪೂರ್ವ ಸೂಚನೆ ಇದ್ರೆ ನಾನೇನೋ ಮಾಡಬಹುದು. ನೀವು ಬರುವಾಗ ನಾ ಏನ್ ಮಾಡ್ಲಿ? you want some swagata here, you should make some arrangement. Somebody should make a request, because the previous course of this thing shows regularly your side used to be absent. Because this is coming up for the 8th or 7th or 8th time before me. This is my personal observation. ಹಾಗಾಗಿ ನನಗೂ ಸಾಕಾಗಿ ಹೋಗಿದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನಾದ್ರು ಮಾಡ್ಕೊಡಿ. ಹಳೆ ಕೇಸ್ ಇದೆ.
48 KN ಹರೀಶ್ ಬಾಬು. KN ಹರೀಶ್ ಬಾಬು.
ಹ 1292 company appeal. Where is R. J. Prakash? ಈಗ ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಯಾರಿಗೆ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? ಅವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ. ಆಯ್ತು, ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ರೆಕಾರ್ಡ್ ದಟ್. ನೋ ಶ್ರೀ ತಮ್ಮ ಹೆಸರೇನು? BC Tippeswamy. Learned Counsel Shri BC Tippeswamy submits that Learned Counsel Shri R. J. Prakash is unwell. Next week hakada? Next week.
50 Omare. 50 O Mahesh. ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಓ ಮಹೇಶ್.
ಶ್ರೀ ವಿದ್ಯಾ ಅಲ್ಲ, ವಿಶ್ವನಾಥ್ ಅಂದ್ರೆ
ಶ್ರೀ ವಿದ್ಯಾ. ಶ್ರೀ ವಿದ್ಯಾ TN ವಿಶ್ವನಾಥ್.
ಮಹೇಶ್.
ಓ ಮಹೇಶ್.
ಮ್ಯೂಟ್ ಮಾಡಿದಾರಲ್ಲ,
ಅವ್ರು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲಿಗೆ ಹೊರದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. Mr. Mahesh. Mr. Mahesh, your case.
ಓ ಮಹೇಶ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
In case of
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೆ ಸರ್, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೆ.
ಇಂಫೋನೇ ಎತ್ಕೊಂಡಿದ್ರು.
Thank you, Raju. Thank you. Good. Thank you. What can I do? I am waiting for people. Our assistant Puji, Srividya.
Srividya, GK. TN Vishwanath.
It's your case.
Serial number?
50.
Yes. An appeal by the insurance company on issue of the insurance.
53 to.
No, it is 50, sir.
50, my lord.
Please.
MFS 6192.
ನಂದು ಇಂಟರ್ನೆಟ್ ಸರಿಯಾಗಿ ವರ್ಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ.
ಈಗ ಏನ್ ಮಾಡೋದು?
Serial number 50, my lord.
Yes, Mahesh. Yes.
TN Vishwanath.
Yes.
MFA 6192 of 2010, my lord.
Right.
Yes. Appeal by the insurance company on question of liability, my lord.
Come immediately.
The main ground, my lord, that the driver of the, my lord, insured vehicle was charge sheeted under section 3(1). Therefore, we are not liable. It's an issue of similar. Now it is covered by, my lord, Amrut Paul and Rani, my lord.
Then pay and recover.
Pay and recover would be the, my lord, thing.
You are quantum ಬಗ್ಗೆ ನಿಮ್ದೇನು question ಇಲ್ಲ ಅಲ್ಲ?
On quantum, my lord, the grounds which I have taken, my lord, may not hold water today.
Correct. ಅಂದ್ರೆ ಇನ್ಕಮ್ 4,000 ತಗೊಂಡಿದ್ದಾರೆ ಕಾಣ್ತದೆ.
2008 matter. Only on this issue, you must kindly dispose it of.
Very well. So you ನಿಮ್ದೇನ ಅಪೀಲ್ ಇಲ್ಲ ಅಲ್ಲಮ್ಮ?
ಇಲ್ಲ, ಯಾವುದು ಇಲ್ಲ.
This appeal is at the instance of the insurance company. Calling in question the correctness of the judgment and award dated 22/2/2010 in MEC so and so passed by so and so. The only contention taken up by the learned counsel Shri O. Mahesh.
One of the contention and
right. The principal contention taken up by learned counsel Shri O. Mahesh for the appellant insurance company is that the charge sheet was filed against the driver of the offending vehicle for offences inter alia, section 31 of
3 within bracket 1.
Section 3 within bracket 1 of
the MV Act.
1988, namely that the vehicle was applied without permit. ಅಂದ್ರೆ ನಾನು ನೀವು you graciously submitted ಅಂತ ಬರಲ್ಲ, ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಡವಾ? Okay.
Does not hold water. That's why, in view of the recent ruling, the question of quantum does not arise.
However, in view of the recent ruling of the Honorable Supreme Court in Rani and others versus National Insurance Company Limited and others within bracket 2018 8 SCC 492 and Amritpal Singh. He said submission will not hold water and the appropriate order to be passed. ಇಲ್ಲಿ ಇವರು ಪೇನ್ ರಿಕವರ್ ಮಾಡಿದ್ದಾರೆ ಮಾಡಿದ್ದಾರೆ. And therefore the appropriate direction to be issued in this case is for the appellant insurance company to pay the award amount along with the interest in the first instance and thereafter to recover the same from the insured owner. Idralli avanu yaru respondent andre Pradeep D'Souza na recover the same from respondent number 3 V Pradeep D'Souza. Correct tane?
Yes.
Pradeep D'Souza alias V Pradeep, ಅದು ಕಾಸ್ಟ್ ಟೈಪ್ ನಲ್ಲಿ ನೋಡಿ ಅಪೀಲ್ ನಲ್ಲಿ R3 in the same proceeding. So the above appeal is disposed of. ಏನಮ್ಮ? ಸೊ ಅಲ್ಲಮ್ಮ, ಇಲ್ಲಿ ಈಗ ಅವರು ಎಷ್ಟನೇ ಅವರು ಇಲ್ಲಿ ಈಗ ಮನು ಸೇತಿ ಅಂದ್ರೆ R4 ಅವರ ಹೆಸರು ಮನು ಸೇತಿ ಹೌದಾ? ಹಾಗಿದ್ರೆ R4 ಮೇಡಮ್. ಈ ಅಪೀಲ್ ನಲ್ಲಿ R4 ಮನು ಸೇತಿ ಅದು ಬರ್ಕೊಳ್ಳಿ, ಇಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ. ಫಾಸ್ಟ್ ಆಯ್ತು. Recover the same from respond number 4 Manu Sethi in the same proceeding. The above appeal is disposed of accordingly. The amount in deposit shall be transmitted to the learned MA Sethi along with the records forthwith. No problem.
Appeal by the insurance company. On the ground, my lord, that driver of the insured vehicle, my lord, had no license at all.
ಅದೂನು ಅದೇ ಪರಿಸ್ಥಿತಿ.
Same thing, my lord. It is on a different footing, but my content will not be accepted by the court.
Okay.
Having a license is different and not similar.
ಎಲ್ಲ ಅದೇ ಇವನ್ ಎಲ್ಲ ಒಂದೇ ಆಮ್ನಿ ಬಸ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ವಲ್ಪ WC ನಲ್ಲಿ ಅದೊಂದು ಯಾವುದೋ ಒಂದು ಬಂತು, ಅದು ಸ್ವಲ್ಪ ಅಷ್ಟು ಸ್ಪಷ್ಟತೆ ಇಲ್ಲ ಅದರಲ್ಲಿ.
They said that defense is not available for so far as the employee is concerned.
ಅದು ಸ್ವಲ್ಪ ಇನ್ನೂ ಪ್ರಾಪರ್ ಎಲ್ಯುಸಿಡೇಷನ್ ಆಗ್ಬೇಕು. ಅದು ಯಾವ್ದೋ ಹಿಮಾಚಲ್ ಪ್ರದೇಶ್.
They are not a third party, therefore this ruling will not apply ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಇದು ಅಷ್ಟೇ, ಎರಡು ಕೇಸಲ್ಲೂ
ಅದಕ್ಕೆ ಲೈಸೆನ್ಸಿಗೆ ಯಾವ್ದು ಡಿಸಿಷನ್?
No DL at all is the
these two appeals are at the instance of the insurance company calling in question the correctness of the common award dated common judgment and award dated 25/3/2010 in MEC 2711 and 2712 of 2009 by so and so.
Driver of prosecutor and section 3 within bracket 1 also, exhibit P3.
the principal contention advanced on behalf of the appellant insurance company by learned counsel C.O. Mahesh is that the driver of the offending vehicle was not in possession of valid and effective driving license at the time of the accident, and therefore
he was charge sheeted under section 3(1) in the road.
Was not having a valid and effective driving license, and he was charge sheeted inter alia for the offence punishable under section 3(1) of the MV Act 1988.
As per exhibit P3.
As per exhibit P3. Good stuff. However, the said contention will not hold water now in light of the catena of decisions of the Honorable Supreme Court and this court, and the proper direction to be issued in these two appeals is for the insurance company to deposit the award amount along with the interest payable thereon in the first instance, and thereafter recover the same from ಇದರಲ್ಲಿ ಅಪೀಲ್ ನಲ್ಲಿ ಯಾರು ಬರ್ತಾರೆ? ಇದು ಓನರು, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅಲ್ಲ?
Respond number. Service was held sufficient. 3 days.
Gangadharam. Respondent number 2 are Gangadharam in the same proceeding. To start. The above appeals are disposed of accordingly. The amounts in deposit shall be transmitted to the learned MACD forthwith. A.N. Krishnaswamy, P. Ravindra, ಇದರಲ್ಲಿ B. Pradeep, ಯಾರು ಇದರಲ್ಲಿ?
N. Krishnaswamy.
Mr. Krishnaswamy. Mr. Krishnaswamy. Pradeep. Madam.
Pramod ಇದೆ. B. Pramod.
ಇಲ್ಲ ನಾನು ಅದರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಬಿ ಪ್ರದೀಪ್ ಅವರು ಇದ್ದಾರೆ ಅದರಲ್ಲಿ.
ಒಂದ್ ನಿಮಿಷ, ಇವರು ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು ಅವೈಲೇಬಲ್ ಇದ್ದಾರಾ ಅಂತ ಸ್ವಲ್ಪ ನೋಡಿ, ಅಥವಾ ಪ್ರದೀಪ್ ಇದ್ದಾರಾ ನೋಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇಲ್ಲ, ಅವೈಲೇಬಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇಬ್ರು ಇಲ್ವಾ?
ಟೋಟಲ್ 6 ನಲ್ಲಿ
ಟೋಟಲ್ 6 ನಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
ಪ್ರದೀಪ್ ಅವರು ಇದ್ರು ಸ್ವಾಮಿ.
ಇದ್ರಾ? ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬೋದಾ ನೀವು?
ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ತಿಳಿಸ್ತೀನಿ.
Okay.
I'll request Mr. P.B. Raju, my lord, to inform our hatra ide Krishnaswamy. ಹೇಳ್ತೀನಿ ನಾನು.
Okay.
I'll inform them.
Thank you.
P. Ravindra.
You have dialed is currently.
Pass over Madada. Next 53.
Appear for the appellant, my lord, in MFA 6647 of 10, my lord. My case is on the issue of no permit, my lord.
1 minute. 53. The 7322 ಯಾವ MVC ಅದು MVC number?
3595.
No, I want to, because it's against common order, so that it becomes easier for me to appreciate the facts. If I know which appeal is against which MVC order.
3595 of 2008.
7322.
Out.
Again, please repeat MVC.
MVC number 3595/2008.
Then 6647.
That is also 3595 of 2008.
Okay. And then 7332. You do not know?
ನಾನು ಫಸ್ಟ್ ಹೇಳಿದ್ದು 7322 ಐ ಆಮ್ ಸೋ ಸಾರಿ ಮಿಲರ್ಡ್. ನನ್ನ ಹತ್ರ ಇರೋದು ನಾನು ವಕಾಲತ್ ಹಾಕಿರೋದು 7322 ಹಾಕಿದ್ದೀನಿ. ದಟ್ ಈಸ್ ಬೈ ದಿ ಕ್ಲೈಮೆಂಟ್ ಸೀಕಿಂಗ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಇನ್ MVC 3595 of 08.
So
7322. I have the appeal memorandum.
Okay. 7322 and 6647.
Yes.
Both arise out of MVC 3595 of 2008.
Yes.
Alva?
That's correct.
One ನಿಮಿಷ. Mr. Mahesh?
Yes, ma'am.
These 7332 arises from which MVC?
That is not 7333 arises out of 342, my lord.
342
of 2007.
2007.
And 7332 arises out of 341 of 2007. MSc.
Okay. And then this crop 57 of 2011, that also 341, is it?
But I am not aware, but I am appearing only in two matters.
No, yeah, 53.4 ನಲ್ಲಿ ನೀವು ಇದ್ದೀರಿ. ಕ್ರಾಪ್ ನಲ್ಲಿ ನೀವು ಇದ್ದೀರಿ.
ಅವರು ಹೊಸಮಠ ಹಾಕಿದ್ದಾರೆ.
ನೀವು ಇದ್ದೀರಿ. ಅದರಲ್ಲಿ ಅದು 341 ಇಂದಲೋ ಅಂತ, ಯಾಕಂದ್ರೆ 7332 ಅಂತ ಇದೆ.
There is a cross objection, my lord.
Yes, sir.
There is some
ಲಾಸ್ಟ್ ಟೈಮ್ ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಕನೆಕ್ಟ್ ಆಗಿತ್ತಲ್ಲ, ತಾವು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅವಾಗ ಇದು ಒಂದು ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಇದು
ಯಾವ್ದೀಗ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಾ ಇನ್ನು?
ಪ್ರಾಬಬ್ಲಿ ಮೈ ಲಾರ್ಡ್, ಬಿಕಾಸ್ ಮೈ ಮ್ಯಾಟರ್ಸ್ ಆರ್ 7332, 7322 and 6647, my lord.
They are different, arising from different.
The date of accident ಕೊಡ್ತೀನಿ, so that my lord, Mr. Mahesh can check it, my lord. 8/3/2008 is my date of accident.
Your cases, Mr. Madam Renuka,
yes,
your cases arise from which MACT?
MACT Bangalore.
Mr. Mahesh's cases arise from which MACT?
My two opinions, my lord, regarding Maddur MACT, my lord, 341.
Definitely ಅದು separate ಅದು.
Separate ಆಗಬೇಕು.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ 50 ಮ್ಯಾಟರ್ ಇತ್ತಲ್ಲ, ತಾವೆಲ್ಲ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ, ಅವತ್ತಿತ್ತಿದೆ.
ಈ ಮೂರು ಒಂದು ಸರ್, ಕ್ರಾಸ್ ಅಪೀಲ್ 57, 7333, 7332 ಇದು ಇವೆರಡು ಒಂದು.
MFA 7333 of 2010.
Right.
Okay. Has filed cross objection.
So, Madam ಬರ್ಕೊಳ್ಳಿ ಆಯ್ತಾ. MFA MFA 7322 bar 2010 and MFA 6647 bar 2010 arise from the judgment and award passed in MEC 3595 of 2008 of MACT Bangalore Full stop. MFA 7332 of 2010, 7333 of 2010,
Arise out of
MFA CROB 57 of 2011, arise out of the award passed in MEC 341 of 2007 of MACT Maddur. Allah?
341 and 342.
ಅದು Maddur ಅಲ್ಲ?
Maddur.
Arise out of common award passed by MACT Maddur. Therefore, the first 53 and 53.1 shall be taken up together, and they are delinked from the other three appeals. 53.2, 53.3, and 53.4 shall be taken up together as they arise out of a common judgment and award. So, if you are ready, we will take up all these two first separately, the other three separately.
But next week, or Monday, it may be.
53.2 to 53.4 list next week as requested by Sri O. Mahesh. Both Harish Babu and Renuka are ready.
I'm ready, ma'am.
Where is Mr. Harish Babu?
Probably ತುಂಬಾ ಕನೆಕ್ಟ್ ಆಗಿತ್ತು ಅಂತ ಏನೋ ಬಂದಿಲ್ವೋ.
ಆಯ್ತು, ಹಾಗಿದ್ರೆ ಇದು ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಈಗ ಕ್ಲಾರಿಟಿ ಆಯ್ತಲ್ಲ? ಅವರು ಮಿಸ್ಟರ್ ಹೊಸಮಠ್ ಕಾಯ್ತಾ ಇದ್ರಲ್ಲಿ, ಅವ್ರಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ತಿಳಿಸ್ಬಿಡಿ ಯಾರಾದ್ರೂ.
ಅಲ್ಲ, ಇದ್ದಾರೆ.
ಮಂಡೇ. Please inform him.
He is the con-subject Monday.
He 54. We take 5 minutes break. 5 minutes break.
Ayyappa.
ಶರಣ್
ಹೊಸಮಠ್ರಿ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸಾರಿ
Madam Renuka?
Lord, in this case, my lord, I request for a week's time, my lord. ಸ್ವಲ್ಪ ಯಾಕೋ ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತಾ ಇದೆ ಎಲ್ಲ ಇದು ಫ್ಯಾಕ್ಟ್ಸ್ ಸ್ವಲ್ಪ.
Srimati HR Renuka, London Council for the brief for time. List next week.
My lord, he wants Mr. P.B. Raju request for a passover, my lord. He's going to appear physically, my lord. He's on his way, my lord.
Okay, fast one. Is injury or death? C.R. N. Gopalakrishna. It is submitted that Sri N. Gopalakrishna is unwell and he is hospitalized. Yeah, the next week. This next week.
Krishna Swami.
Inform ಮಾಡಿದ್ದಾರೆ. I requested P.B. Raju, my lord. He has informed him, my lord. To come. Probably it may be passed over, my lord.
Mr. Mahesh?
Oh, Mahesh.
Mr. Mahesh?
My lord, we'll call him and inform him, my lord. Forever. ಈಗಲೇ ಮಾಡ್ತೀನಿ.
Okay. Right. ಮುಂದೋಗ ಅದು ಉಮೇಶ್ ಅವ್ರದ್ದೇ, ಇನ್ನೆಲ್ಲ ಅವ್ರದ್ದೇ ಇದೆ.
It's not received.
Mr. Mahesh, this serial number 58.
58. May I request for a password, my lord? Somebody has come.
Okay. Fast over. But then next ಎಲ್ಲ ನಿಮ್ದೇ ಇದೆ.
ಬಂದೇ ಇಲ್ಲಿ ಯಾರು ಬಂದಿದ್ದಾರೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ.
ಇದೆಲ್ಲ ಅವರೇ. ಆಯ್ತು.
I'm appealing for the appellate, my lord. Insurance appeal, my lord, on liability issue, my lord. ಇದರಲ್ಲಿ ಏನಂದ್ರೆ ಸ್ವಾಮಿ, ಇನ್ಶೂರ್ಡ್ ವೈಫ್ ಪಿಲಿಯನ್ ರೈಡರ್ ಆಗಿ ಸತ್ತೋಗ್ಬಿಡ್ತಾಳೆ ಹೋಗುವಾಗ, ಸ್ಕಿಡ್ ಆಗಿ ಬಿದ್ದು. Our insured is the claimant. Claimant insured himself is the claimant, my lord. That is the only issue before this court. Not liable. I am not liable to pay the compensation which was awarded by the learned judge.
He was the rider also?
No, he was not the rider, my lord. Rider is different, my lord. Rider is by name Harisha. Harisha scooter wife, your insured wife and karkondu devasthanಕ್ಕೆ ಹೋಗ್ಬಿಟ್ಟು ಬರ್ತಾ ಇರ್ತಾರೆ. ಸ್ಕಿಡ್ ಆಗಿಬಿದ್ದು EMS ಸತ್ತೋಗ್ಬಿಡ್ತಾಳೆ. ಇವರು ಕ್ಲೈಮೆಂಟ್ ಬಂದು ಇವ್ರ ಹಸ್ಬೆಂಡ್ ಶ್ವೇತಾ ರಾವ್ ಹಸ್ಬೆಂಡೇ insured. He admits I am insured anta. So insured himself is not liable to get compensation from his own vehicle, my lord. That is only the issue before this court.
Where is Mr. K. Shekara? Mallikarjun Basareddy. Who is the claimant in this, Mr.
Husband of the
his rank in the appeal, no?
R1, sir. R1, my lord. First claimant, R1, Ashok Rao.
Who is R2?
R2 is the Orient Insurance Company, my lord.
Allah. Our ಒಬ್ಬರೇ ವಕೀಲರು ಇನ್ಶೂರೆನ್ಸ್ ಎಲ್ಲ.
R2 is the Bhagyabai, mother of the claimant. How Swami? She is not. Adu in the cross examination, they have come to the conclusion that she is living separately.
Yes. Last time I remember to have asked whether she is class 1 heir. She is not. But yes, whether she, are there any decisions which say mother can also claim from for the death of the mother?
Illa, my lord. For that reason, I will take my lords to the cross examination of the Ashok Rao itself, my lord. Who said she is his mother-in-law. She is resides separately with her husband, with her 2 daughters and son. She is not a claimant anta ಅನ್ನೋದನ್ನ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. My lord, I will take for a few seconds, my lords, to the statute book itself, my lord, the Motor Vehicle Act.
Motor Vehicle Act.
163A first.
ಇದು 163 ಏನಾ ಇದು?
ಅಲ್ಲ, ಇದು 166, my lord. But ಏನು ಅಂತಂದ್ರೆ 163A ನಲ್ಲಿ unless owner suffers a liability, insurer should not suffer liable anta. That is the
what do you want me to read?
163A ಬನ್ನಿ ಸುಮ್ಮನೆ ನಾನು ಓದ್ತೀನಿ ಇವಾಗ. 163A special provisions as to payment of compensation on structured formula basis, sir. Notwithstanding anything contained in the act or any other law for the time in force or instrument having force of law, owner of the motor vehicle of the authorization shall be liable to pay. That there I will stop there, my lord. Hence, owner of the motor vehicle, unless he is liable to pay, I should not suffer any liability. Then I will take my lord.
You are an indemnifier. There is no doubt about it. An insurance company is an indemnifier. Unless the principal is liable to pay, you are not liable to pay. You don't have any independent liability.
Exactly, my lord. Next, I will take my lords to 165.
165.
Yes, my lord. Shall I read, my lordship?
Yes, sir.
A state government may, by notification in the official gazette, constitute one or more extant tribunals, herein after this chapter referred to as claims tribunal, for such area as may be specified in notification for purpose of adjudicating upon claims for the compensation in respect of accidents involving the death or bodily injury to or persons arising out of use of the motor vehicle or damage to any property of a third party, arising or both. Then I will take my lords to 166, my lord. 166. Take my lords to 166, my lord. Something
Yes.
there.
Yes.
Proceedings under section 163A and 166 can go together. Orderly last para, my lord. The Motor Vehicle Act 1988 does not define the expression legal representative in section 166 of the Act or any of the defining sections, section 2 of the Act. Therefore, the definition of legal representative as provided under 211 of the CP code has to be referred to. Thus, a person in law who represents the estate of the deceased or the person who intermediates with the.
Okay, Mr. Chandrasekhar has to be heard. Hey, Chandrasekhara. Okay, we will take that later. Let's see when he comes. Huh?
ಅದೇ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಮೈ ಲಾರ್ಡ್
wait.
ಸರಿ
ಅಂದ್ರೆ ಅವರು ಇಲ್ಲ, ಅವರು ಕೆ ಚಂದ್ರಶೇಖರ್ ಬರ್ಲಿ.
ಆಯ್ತು ಆಯ್ತು. ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಡ್ರೈವಲ್ ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅಲ್ಲೇ ಇತ್ತು ಸ್ವಾಮಿ.
ಮಹೇಶ್
ಸರಿ.
ಓ ಮಹೇಶ್
ಮೊದಲೇ 58 ನಿಂದ ಕೆ ಚಂದ್ರಶೇಖರ್ ಇಲ್ಲ. ಪಿ ಬಿ ರಾಜು ಅವ್ರದ್ದು ಯಾವುದು?
55.
55 ಪಿ ಬಿ ರಾಜು. You are ready? What is this matter about? PV Kalpana. PV Kalpana. Which is the policy? Internal.
As it is an act policy, I have reviewed the policy and I have also citations read upon by the petitioners reporting and so and so, whether which is held so and so. Motivating whether applicant is third party and insurance debt. I have also gone through the citations read by the corresponding to the ACK 6 days of divided in the section. Motor Vehicle Act section 147. Policy private vehicle in granted liability of length of period of insurance act policy. Not contain any of payment of additional premium insurance company is not valid. By looking at the insurance policy, I have considered admittedly in cross-examination stating that the policy includes two-seater. Because it is a two-seater, it says.
Record, madam, record kodi. RW1 ತೆಗಿರಿ. Which is the policy, Mr. Raju? RW1 ಮತ್ತೆ exhibit R1. TV Kalpana. ಅವರಿಗೆ ಗೊತ್ತಿದೆಯಾನ ಅವರಿಗೆ? Can you inform her? ಬೇಡಪ್ಪ, ಇನ್ನು ಇದನ್ನು ಇಷ್ಟೇ ಪಾಯಿಂಟ್ ಇರುತ್ತೆ, ಸ್ವಲ್ಪ ಅವ್ರ ಹತ್ರ ತಗೊಂಡು ಮಾಡ್ತೀರಾ? ಅಷ್ಟೇ, ಸೀಟಿಂಗ್ ಕೆಪಾಸಿಟಿ ಇಷ್ಟು ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದವರು. Liability only policy. How much was awarded? ನಮ್ಮ ತಿಲಕ್ ಸಿಂಗ್, ಸುಧಾಕರನ್ ಮತ್ತೆ ಬಾಲಕೃಷ್ಣನು ಬರ್ತದ. ಮಹಾದೇವ್ ಡಿವಿಷನ್ ಬೇ. This appeal is at the instance of the insurance company calling in question the correctness of the judgment and award dated 29/3/2010 in MVC so and so by so and so. Okay, thank you, madam. Thank you. This is purely a legal point. Don't worry, you sit down. The claim petition is at the instance of the legal representatives of one Vairamudi Gowda, who had on 31/7/2007 at about 5:45 a.m. while traveling as pillion rider in a Bajaj Chetak scooter bearing registration number KA 11J6211 had died due to the rash and negligent driving of the said two-wheeler by its rider, due to which two-wheeler had collided with dashed against a road divider. Full stop. Learned MACT, upon appreciation of the evidence, awarded a compensation of Rupees 3,94,000 with the interest thereon, and the liability to pay the same was fastened, F-A-S-T-E-N-D, fastened on the appellant hearing. Next para. The only substantial contention raised by the learned counsel for the appellant, Shri P.B. Raju, is to the effect that the direction in the award against the appellant insurance company to pay the award amount is illegal, in as much as Exhibit R1, the policy of insurance is an act policy, and further, no additional premium was collected to cover the risk of pillion rider. Full stop. Next para. I have perused the judgment and award called in question in this appeal. In regard to the liability of the insurance company, learned MACT has observed that though Exhibit R1 is an act policy, in view of the admission of RW1 that the policy included two-seater, the insurance company is liable to pay the compensation awarded. I have perused the deposition of RW1. He has merely stated that the seating capacity of the offending vehicle is 2. He has nowhere admitted that the policy exhibit R1 covered the risk of the pillion rider of this offending vehicle. Careful perusal of exhibit R1, the policy of insurance, shows that it is an act policy and no additional premium covering the risk of the pillion rider has been collected by the appellant insurance company. The point involved in this appeal is squarely covered by the decision of the Honorable Supreme Court in Tilak Singh, Sudhakaran, and a division bench of this court reported in ILR 2011 Karnataka 850 within bracket the branch manager from the New India Assurance Company Limited versus Mahadev Pandran Party. In view of the above decision, the deceased being a pillion rider of the offending two-wheeler, which was issued with an act liability policy by the insurance company without any additional premium being collected to cover the risk of the pillion rider, insurance company is not liable to pay the compensation awarded for the death of the deceased pillion rider. In that view of the matter, the direction in the award to the appellant to pay the compensation amount is unsustainable and it is set aside. Hence the following, the above appeal is allowed. The direction in the judgment and award dated so and so in MVC so and so by so and so, to the extent there is a direction to the appellant to pay the compensation amount, the compensation awarded is set aside. The amount in deposit shall be refunded to the appellant forthwith. Transmit the records to the learned MACT.
Seven, Krishna Swami. 7 N Krishna Swami.
Indian matter. Decision. But the insurance company did not inform you about. When was the accident? After the information or before the information?
The accident after the 25
Supreme Court decision. Supreme Court decision.
Yes.
Krishna Swami, why Krishna Swami is not appearing? ತಗೊಳ್ಳಿ ಒಂದು ಕಾಪಿ ನೀವು ತಗೊಳ್ಳಿ. Which paragraph in Lakshmama case, Mr. Counsel? (26) and 27.
insurance from the insurer for the period 16 to 2004 to 15 the accident occurred on 11/5. Thereafter, the insurer cancelled the insurance policy. Dated 30 of Dishonored was received by the owner of the vehicle and controlled by the cancellation policy after the accident. The insurer is liable to satisfy the amount of compensation. In this case also, accident occurred on 25/8/2007.
1 minute. Accident is on 25. Accident into 2007.
Cancellation letter communicated on 13/9/2007.
ಅದು ಲೆಟರ್ ಡೇಟಾ ಅಲ್ಲ ನಿಮಗೆ ತಲುಪಿದ್ದ ಲೆಟರ್ ಈಸ್ ಡೇಟೆಡ್ ಯಾವಾಗ ಡೇಟು ಇದು ಇನ್ಶೂರೆನ್ಸ್ ಯಾವ ಡೇಟ್ Where do you get this? ಇಲ್ಲಿ ಡಿಸ್ಕಷನ್ ನಲ್ಲಿ ಏನು ಹೇಳಿಲ್ವಾ ಇವರು
The accident occurred was simply part of travel of affected vehicle. As regards the validity of the policy of affected vehicle is concerned, senior executive of the second respondent has been the one and
RW.
And he admits that the affected vehicle was initially issued in this company and a cover note was issued for the period from 14/8/2007 to 30/8/2008. It is stated that payment of premium of fees 3,42,950 was made by way of the consolidated check on date 31/7/2007, bearing number 623160 by respondent number 1. It is further contended that the bank has informed to the second respondent about dishonour of check with an endorsement as funds insufficient, and thereafter second respondent addressed a letter dated 13/9/2007 to the first respondent reporting the dishonour of check under contract of insurance is quite ab initio in view of dishonour of the check, and the risk is not covered under the said cover note since the fee cannot be issued. It is also stated that the accident took place on 25/8/2007 and the cover note was cancelled by the letter dated 13/9/2007. Therefore, there is no privity of contract between first and the second respondent, and accordingly it was urged to settle liability on the owner of the vehicle. After the oath is also spoken to the documents that exhibit R1 to R8 has been cross-examined by the chief, and during the course of cross-examination, he admits that as per exhibit R1 cover note, the initial premium and I feel like RW was given explanation valid that there is a mention of check number under exhibit R1 cover note, and as per the exhibit R2 further admits that premium amount is that policy is shown under the report. The policy was issued in consonance with the government. He admits that the date of accident prior to the Dishonored. So, as consolidated check is concerned, he admits that he has not produced any documentary evidence for that the other vehicles premium was also included in the consolidated check. So that considering all these technical facts, I guess that the stand taken with the second respondent was not consistently to face any material evidence under whatever the evidence based on recording probability and quite inconsistent with regard to the payment of premium. Admittedly, the government and policy was cancelled subsequent to the date of the accident. Therefore, at this stage, there is no sufficient evidence on behalf of the second respondent to see that this is not covered under the insurance policy. The observation.
Okay. Tagwali. This appeal is at the instance of the insurance company calling in question the correctness of the judgment and award dated 19 to 2010 in ME so and so by so and so. The claimant was awarded a compensation of rupees 56,550 with the interest thereon by way of compensation for the bodily injury suffered by him in an accident. Next paragraph. The substantial contention of the learned counsel for the appellant is that the check issued was returned dishonored. The check issued by the owner of the vehicle towards payment of premium was returned by the banker, dishonoring the same. And therefore, the policy of insurance was rendered void ab initio for non-payment of consideration amount. And therefore, the insurance company is not liable to pay the compensation. Full stop. It is therefore submitted that the direction in the award to the insurance company to pay the compensation awarded is illegal and liable to be set aside. Next paragraph. Perusal of the records, including the impugned judgment and award, shows that the appellant insurance company had issued a policy of insurance for the period commencing from 14/8/2007 to 13/8/2008 to the offending vehicle. Full stop. The accident occurred on 25/8/2007, resulting in injuries to the claimant. On account of the dishonor of the check issued by the insured towards payment of premium, the appellant insurance company issued a cancellation of the premium letter dated 13/9/2007. That is subsequent to the occurrence of the accident. The question now is whether in the facts and circumstances of this case, the policy of insurance issued under Exhibit R1 Exhibit R1 entry under Exhibit R1 is rendered void ab initio for non-payment of premium by the insured owner due to the dishonor of check, and therefore no liability can be fastened on the appellant insurance company to pay the compensation as directed by the learned MACT in the impugned judgment and order. The above question is covered by a decision of the Honorable Supreme Court in Vijay Singh versus State of Uttar Pradesh and others within bracket 2012 5 SCC 242. Full stop. The relevant observations of the Honorable Supreme Court are at para 26 and para 27, and they read as follows. The para 26 SCC in the Madhya read as follows. Full stop. As already noticed, in this case, the cancellation letter in this case, cancellation of the policy letter was issued by the appellant insurance company by the letter dated 13/9/2007, that is subsequent to the occurrence of the accident on 25/8/2007. In view of the above decision of the Honorable Supreme Court, the contention of the appellant that it is not liable to pay the compensation amount is therefore untenable. Full stop. Accordingly, there is no merit in the appeal and it is liable to be dismissed. Hence, the following, the above decision, above appeal is dismissed. The direction in the award, the appellant insurance company is liable to pay the compensation as directed in the impugned award and judgment. The amount in deposit shall be transmitted to the learned MACT along with the records forthwith.
I appear for respondent in the connected appeal, my lord, appeal by the insurer.
This is a death case, Allah.
It's a case of death, my lord. Of one was Vatsala Jain, aged about 38 years, my lord. Daughter of the, my lord, the first claimant, mother. Date of accident, my lord, is 14/3/2008 at 9 AM, my lord. Vehicle involved is motorcycle KA 20S 6073.
6073. She was pillion rider.
She was pillion rider. First respondent owner, my lord, the insured, though appeared, no statement was filed. The appellant, my lord, arrayed as a second respondent, contend that it did not be negligence of the, my lord, the motorcycle insured with it. And the claimants are not dependent of the deceased.
She was pedestrian, not pillion rider. Deceased was pedestrian, Allah.
Well, it is shown as Manod thing. Pillion rider. At one place, Manod, it's shown as Manod walking on the side of the road. Anyway, Manod, the accident, Manod, is not disputed.
Andre, avanu deceased was as per the case found by the MACT, deceased was walking or was a pillion ride?
Walking, Manod, walking.
Walking. So now you are disputing only the quantum or liability also?
Quantum, Manod, liability is not disputed.
Not disputed.
Quantum only. The main ground, Manod. PW1, Manod. Admittedly, Manod, she was working as a helper in a Gita clinic, earning rupees, Manod, 5,000 per month. Sorry, Manod, the deceased was working in a Gita clinic, Manod. But the main ground raised by me, Manod, is that mother had an income of her own, admittedly, and the second claimant, Manod, the daughter of the first claimant, is married and living separately with her husband. Therefore, Manod, the dependency allowed by the tribunal to an extent of 2,40,120 is improper. At the most, Manod, the loss to the estate could be, Manod, 50,000 when dependency was not proved and established. In this respect, Manod, I invite your worship attention to, Manod, to ink page 13, para 9. May, Manod? My lord, am I audible, my lord? I'm not hearing, my lord. It is muted, my lord. It is no.
Now fine.
Now, my lord. It was muted.
So this deceased was Vatsala.
Yes, my lord.
And claimant number 2 is her daughter.
Yes, married.
She is married.
Yes.
Married. And claimant number 1 is the mother of the deceased.
And she had her own property, my lord. I invite your attention to, my lord, ink page 12, para 8 and 9 of the, my lord, the judgment.
Yes.
The second respondent in the written statement specifically contended that the first petitioner is not legal heir. She is not dependent of the deceased. Admittedly, the first petitioner is the mother of the deceased, Vatsala Jain. Come in evidence of PW1 that the deceased was married to one Jivanvara Jain 18 years back. Thereafter, 10 years back, they have separated through court decree. And this fact is not disputed by the other side. No document was produced before. It also admitted that the second petitioner, who is subsequently impeded, is the daughter of the deceased Vatsala Jain. She is also married, residing with her husband's house. According to section 15(1) of the Hindu Succession Act, the property of the female Hindu dying intestate shall devolve according to the rules set out in section 16. Firstly, upon sons, daughter, husband. Secondly, upon the heirs of the husband. And thirdly, upon the mother and father. So here in this case, the first petitioner, being the mother of the deceased, comes thirdly. As per section 16 of the Hindu Succession Act, among heirs satisfied in clause 1 of section 15, so in one entry shall be preferred to those in any succeeding entry. So the second petitioner is the daughter of the deceased Vatsala Jain. She is the legal heir of the deceased Vatsala Jain. The husband of had divorced.
Yes.
As divorce, which is not disputed by the other side. No material was placed regarding that. Under section 161C of the Motor Vehicles Act, legal heir or entitled by petition, according to the ruling reported in 2002 Karnataka Law Journal, page 345, a division bench, managing director KSRTC, Bangalore versus Venkata Raman, KS and others, legal representatives ordinarily mean a person who in law represent the estate of a deceased person or person on whom the estate devolved on the death of an individual. In the present case, second petitioner who represents the estate of the deceased, her mother Vatsala Jain, not the first petitioner who is the mother accordingly to sections 15 and 16 of the Hindu Succession Act. Further, it comes in the evidence of PW1 that she is having 7 children and 3 male children and 4 female children and 1 son who is working in Ujre College, and 2 sons are residing separately. Other daughters are married. Further, she has stated that the house in which she is residing belongs to her. The landed properties are also belong to her, but not cultivating. That means to say that she is not dependent on deceased. Therefore, as contended by the second petitioner, the first petitioner is not the legal heir of the deceased Vatsala Jain. Accordingly, she is not dependent on deceased. Hence, the answer issue number 2 in the negative. This is regarding the maintainability of the claim petition and dependency of the claimants. Then, on ink page 15, it proceeds, to hold that the income, my lord, as after deduction of 1/3 at 1,334 into 12 into 15 multiplier to arrive at 2,40,120. And I am disputing, my lord, the dependency. Therefore, my lord, loss to the dependency at the most could be, my lord, 50,000, not more than that. That's all.
Okay. This appeal is ಅವ್ರದ್ದು enhancement ಇದೆಯಲ್ಲ?
ಅವರು enhancement ಹಾಕೊಂಡಿದ್ದಾರೆ.
These appeals are at the instance of the insurance company and the claimant, calling in question the correctness of the judgment and award dated 5/5/2010 in MEC 510 of 2008 by Learned so-and-so. Stop. Learned MACT, after appreciating the evidence and the contentions advanced on both sides, has allowed the claim petition in part and awarded compensation of rupees 2,53,000 with interest thereon at 6% per annum from the date of the petition till the date of payment. Next para. Learned counsel for the appellant insurance company strongly contends that the claimants are the mother and married daughter, widowed mother and married daughter of the deceased Vatsala Jain, having their own resources and having their own resources, full stop. He therefore submits that they were not dependents on the deceased, and in that view of the matter, the liability fastened on the insurance company to pay the compensation as awarded is illegal, and insurance company is liable to pay only a sum of rupees 50,000 at the most. He therefore submits that appeal is entitled to be allowed, and the direction in the award modified to the extent as above. Next paragraph. In support of the appeal filed by the claimant, it is urged that the compensation awarded is on the lower side, and it is required to be enhanced, and appeal is accordingly required to be allowed. Next paragraph. I have given my anxious consideration to the submissions made on both sides, contentions urged on both sides, and I have carefully perused the records. The liability to pay the compensation has not been questioned by the appellant insurance company. Therefore, it is not necessary to make a detailed reference to the facts of the case. Next paragraph. There is no dispute about the fact that deceased Vatsala was separated from her husband by virtue of a court decree. Full stop. Claimant number 1 is the mother, and claimant number 2 is the married daughter. Full stop. The learned counsel for the appellant insurance company has urged that evidence clearly shows that the claimant mother had several other children who were gainfully employed, and therefore she was not dependent on the deceased Vatsala. His further contention is that claimant number 2, even though he is a daughter of the deceased, she is also married, living with her husband, and therefore she is not a dependent. A full stop. Insofar as the above said contentions are concerned, the matter is no longer, the legal position is no longer res integra. The question essentially is not whether the claimants are dependents, but whether they are the legal representatives of the deceased on account of whose death the claim for compensation has been made in view of the express terms of clause C of subsection 1 of section 166 of the MV Act 1988. Honorable Supreme Court in National Insurance Company Limited versus Virender and others within bracket 2020 11 SCC 356 has observed as follows. This is para 14 the SCC in that para 14 and italics. Full stop. Honorable Supreme Court has made it abundantly clear that the status of the claimants regarding their marriage or even their being able to earn some livelihood does not alter the fact that they still continue to be legal representatives of the deceased, and the right to receive compensation only turns on the claimants being the legal representatives within the meaning of section 166 of the MV Act, read with CPC refer ಮಾಡಿದಾರಲ್ಲ ಅದರಲ್ಲಿ read with section 2 within bracket 11 of Code of Civil Procedure 1908. Therefore, the contention of the learned counsel that the claimant number 2, being a married daughter, is not entitled to receive compensation is unsustainable. And accordingly, the said contention is rejected.
May I make one submission, Lord? I'm only saying, Lord, dependency is not proved. They may maintain, Lord.
No, not necessary. No, you have perhaps not been able to hear the order dictated. That is, I have dealt with that. Dependence and legal representative. Now, Supreme Court in the recent decision said the whole question should be examined in the context of the claimant being the legal representative, not being dependent. And in the context, Supreme Court has observed the status of the claimant being an earning person also does not alter the situation. Being major also does not alter the situation. Only true question coming for consent. I have dealt with your dependency and that.
There is no evidence of contribution. I am what saying is, even she was earning, there is no evidence that she was contributing either mother who is living separately and to the married daughter who is living separately with her husband. Therefore, my lord, 50,000 and the head of loss of estate would be reasonable.
Okay. learned counsel in this behalf has submitted that there is no evidence to show that. Learned counsel in this behalf has further contended that there is no evidence produced by the claimants that the deceased mother was contributing anything to the claimant number 2 daughter.
1 and 2.
System. The evidence clearly shows that claimant number 2 being the only daughter and the deceased having been separated from her husband by a court decree, apart from the amount required for her personal expenses, it is only natural that she would contribute the rest of her earnings to her only daughter. PW1 has denied all the suggestions put to the effect that deceased was not contributing any amount and PW1 was being looked after by her other children and that they were paying for her maintenance, etc. In cases of this nature, much evidence cannot be expected regarding the contribution made by the adult members of the family, and regard must be had to the natural course of affairs of life. Therefore, I do not find much substance in the contention of counsel for the appellant insurance company. Next paragraph. The deceased, as per the PME report, was aged 38 years at the time of her death. The appropriate multiplier applicable is 15 for her age. Learned Tribunal has taken her monthly income at ₹2,000. Full stop. The accident took place on 14/3/2008, and therefore the notional income fixed for the said year is ₹4,500 per month, as per the chart prepared by the Karnataka State Legal Services Authority. 1/3 of the notional income of the deceased is required to be deducted towards the personal expenses, towards her personal expenses. Stop. As per the decision of the Honorable Supreme Court in Pranay Sethi's case, citation 40% of the established income of the deceased is required to be added towards loss of future prospects. Accordingly, the loss of dependency is required to be recomputed as follows. Rupees 4,500 minus 1/3 plus 40% into 12 into 15 raised to power attached. A sum of rupees 80,000 is required to be awarded under the head of filial under the head of loss of filial consortium and loss of parental consortium. Another sum of rupees 30,000 is required to be awarded under the convention head. Therefore, the total compensation payable is loss of dependency 80, 30, 1,10,000. The Planet Tribunal has already awarded a sum of enhanced compensation is into a minus the enhanced compensation shall carry interest at the rate of 6% per annum from the date of the petition till the date of the payment. How much? 6 weeks?
From the date of receipt of the certified copy, amount in deposit will be transferred.
Amount in deposit shall be transmitted to the learned MACT along with the records forthwith. 6 weeks time granted for depositing the enhanced compensation before the learned MACT from the date of receipt of certified copy of the judgment. The above appeals, the insurance company appeal dismissed. Your appeal allowed in part.
'59, Kamala DK.
I appear for respondent and my appeal is also there.
They, both have come in appeal.
But the claimant's appeal, my lord, is 2974 of 2011. Company appeal, my lord, is 9951 of 2010. My appeal, my lord, is on question of, my lord, vehicle has been falsely implicated and no liability.
We will continue at 2:30.
Will.
I beg your pardon in the morning by making submission. I made some wrong submissions of the serial number 11 is concerned, Your Lordship. So the other way, except 11 serial number 2730. I made a submission that other 3 cases are covered by Mukund Devan's case. But in fact, except the MFA 2727 of 2280, other 3 matters like kindly be attended by next week, Your Lordship. 11.1 the Mukund Devan case al ಹೋಗಿ ಯಾಕಂದ್ರೆ ಬೇರೆ ಕೇಸ್ 3 ಕೇಸ್ ಅಲ್ಲಿ ಇದು ಇಟ್ಸ್ ಇಂಜುರಿ ಕೇಸ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇಂಜುರೀಸ್ ಅಂತ ಗ್ರೀವಿಯಸ್ ಇಲ್ಲ ಸರ್
ಇಲ್ಲ ಇಂಜುರಿ ಈಗ ಅಂತ ಗ್ರೀವೆನ್ಸ್ ಪ್ರಶ್ನೆ ಇಲ್ಲ. If there are grievous injuries and there is some disability, Honorable Supreme Court, there are 3 decisions. So on that ground,
ಅಂದ್ರೆ ನಾನು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ತೀನಿ ಅವಾಗ 3 ಕೇಸ್ ಅಲ್ಲಿ
ಆಯ್ತು ಈ 11 ಪಾಯಿಂಟ್ ಯಾವುದು ಈಗ ನಿಮ್ದು? ಆಯ್ತು, ಅದನ್ನು ಮಾಡಿಫೈ ಮಾಡಿ. ಯಾರು ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡಿದ್ದು ಅದೊಂದು, ಮಿಕ್ಕಿದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಆಯ್ತು, ಅದು ಸ್ವಲ್ಪ ಅವರಿಗೆ ಹೇಳ್ಬೇಕು.
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಮನಸ್ ಡೇಟ್
2:30.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಹೇಳ್ಬಿಡಿ ಸರ್ ಡೇಟ್.
6/9/17.
17. ಓಕೆ, ಅಷ್ಟೊಂದೇ ಅಲ್ವಾ ನಿಮ್ದು?
ಅಷ್ಟೇ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.
ಹಲೋ ಮೇಡಮ್.
ಬರ್ತಾರೆ, ಇನ್ನೂ ಬಂದಿಲ್ವಲ್ಲ, ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಿರ್ತಾರಲ್ಲ. ಕರೆಕ್ಟ್ ಆಗಿದೆ ಬಿಡಿ ಚಂದ್ರ, ಕರೆಕ್ಟ್ ಆಗಿದೆ ಬಿಡಿ. ಎಲ್ಲಿದೆಯಪ್ಪ? ಇನ್ನೂ ಬಂದಿಲ್ಲ ಬಿಡಿ. 2:00 ಆಯ್ತಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್,
Sir, court officer. Court officer. Court officer.
Kamala DK. O Mahesh. O Mahesh. Yardi. Oh, connected. Citation. O Mahesh.
ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಇದು ನಿಮ್ದೆ.
ಅಲ್ಲ ಅಲ್ಲಿ ಓ ಮಹೇಶ್ ಅಂತ ಕಾಣ್ತಾ ಇದೆ.
O Mahesh. O Mahesh. Mr. O Mahesh, unmute ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಇವರು ಮಗ ಏನೋ 8.
ಅದು ನಂಬರ್ ಕೊಟ್ಟರು ಸರ್, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬರ್ಕೊಂಡೆ.
ಸ್ವಲ್ಪ ಅವರಿಗೆ ಓಮೈಶ್ ಫೋನ್ ಮಾಡ್ಬೋದಾ?
ಆಗಿದ್ದಾರೆ ಬಟ್
ಕಳ್ಸಿದ್ಯಾ?
ಇದೆ.
Next week. ಯಾಕೆ ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ? Next week.
I am appearing for the appellant, my lord. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮು ಮೈ ಲಾರ್ಡ್ ಬಿಫೋರ್ ಲಂಚ್ ಸೆಷನ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅದರಲ್ಲಿ ಒಂದು ಬಿಟ್ಟಿದ್ದೀನಿ, ಅದನ್ನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಹೋಗ್ತೀನಿ ಸ್ವಾಮಿ.
ಮಂಜುನಾಥ್ ಪಟನ್ ಶೆಟ್ಟಿ.
ಬಸರೆಡ್ಡಿ
63 ಮೇಲೆ 6 ಮೇಲೆ ಮಂಜುನಾಥ್ ಪಟನ್ ಶೆಟ್ಟಿ.
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಸಿ ಬಸರೆಡ್ಡಿ. ಸಾರಿ ಸರ್, ಸಾರಿ, ಬಸರೆಡ್ಡಿ ಅವರು.
So, Mr. Basareddy, you appear for whom? You appear for whom? It's Basareddy. Mute ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Mr. Basareddy, please unmute yourself.
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಬಸರೆಡ್ಡಿ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ನಿಮ್ದು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Next week.
ಸರಿ. Obligement.
ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ರವಿಕುಮಾರ್. BC Sitaram Rao.
My lord, sorry. Oh, Mahesh is online, my lord. Probably due to...
audible, my lord?
Hello.
Hello.
Mahesh is online, my lord, now.
He is online, but I can't hear him.
Oh,
I come to the different, my lord. Other one, it was not audible. Now I come to a different instrument, my lord. Now your lordship is audible.
Now I can hear you. Now I can hear you clearly. But right now I have moved little forward to Mr. Ravi Kumar, 62, serial number 62. Because I was waiting to get connection with you. There was some problem.
I'll wait, my lord. I'll wait.
So 62. Sitaram Rao. ಇದ್ರೆ ಅವರು ಏನೋ ಇವತ್ತು ತೊಂದರೆ ಇದೆಯಾ ಅಂತ, ಯಾಕೋ ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ. ನನಗೂ ಕುಂಗಾಡಿ ಸಾಕಾಯ್ತು.
ಸೀತಾರಾಮ್ ರಾವ್. ಅನೂಪ್ ಸೀತಾರಾಮ್ ರಾವ್.
Your petition was dismissed, is it?
the court petition and then the same accident, arising out of the same accident.
Huh.
Having allowed, granted the compensation to the claimant. This appeal may have the petitioner, the appellant, or the traveler in the bus, or the passenger in the bus. The collision between the bus and the lorry. The charge sheet has been.
ಅಲ್ಲ ಮತ್ತೆ ನೀವು ಕಾಮನ್ ಇದ್ರೆ ನಾನು ಯಾಕೆ ಲಿಂಕ್ ಮಾಡಲಿಲ್ಲ? On what ground this was dismissed?
2011, wherein the earlier petition made the last on 13th January 2010.
They were filed by other passengers. ಈಗ ನಿಮ್ದಲ್ಲಿ I think you are not able to prove any injury.
Yes, sustained 4 injuries. 4 ribs were fractured.
Little bit does not have any documentary evidence about his treatment and medical expenses.
Medical expenses.
Exhibit P4 produced by him is a true copy of wound certificate obtained from police. So, because it does not bear the designation of the person who has signed it and seal of the hospital. ಸುಮ್ಮನೆ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀರಿ. ಅಲ್ಲಿ Mr. Ravi Kumar, it may be in the correct format, but mere format is not sufficient. The doctor should sign it. What is the exhibit estado? Wound certificate. P4, put him, madam. ಅವರ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಪರ್ಪಸ್ ಏನು? ಇಲ್ಲಿ ನಾ ಒಂದ್ ಸ್ವಲ್ಪನಾದ್ರೂ ಒಂದು ಅಥೆಂಟಿಸಿಟಿ ಇಲ್ಲ, ಅದರ ಮೇಲೆ ನಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಹಾಕುದು ಹೇಗೆ? No, Ravi Kumar, and trial court especially has said I can't trust it. And how can I trust such a document when the infirmity is there?
But police, the police have collected the wound certificate of mine from the hospital.
Ravi Kumar, these are all little, serious issues. I am not saying anything. I am also not, definitely I can't come to conclusion. Maybe that your client suffered some injury, but the fact that he suffered injury cannot be accepted on the basis of a wound certificate which is only in the format and without some authentication.
Exhibit P1, police notice. My name is disclosed because I was involved in the accident, in the same accident. My name has been recorded with the police. And in the exhibit P1, exhibit P1 is one ವ್ಯಕ್ತಿಯ ಹೆಸರು ಮತ್ತು ಪೂರ್ಣ ವಿಳಾಸ, ಗಾಯಗೊಂಡ ವ್ಯಕ್ತಿಯ ಹೆಸರು ಮತ್ತು ಪೂರ್ಣ ವಿಳಾಸ ಮೊಹಮ್ಮದ್ ಅಲಿ.
ನಿಮ್ಮ ವಿಟ್ನೆಸ್ ಅನ್ನು the problem I understand your concern for your client, but the quality of evidence is very, very bad, very poor. I am not, don't think that I am criticizing you. The way it was conducted before the trial court, therefore, learned judge is correct.
Certificate and civil signature doctor ಇಲ್ಲ
ಮತ್ತೆ ಒಂದಲ್ಲ ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ ಹೇಗೆ? ನೀವು ಡಾಕ್ಟರ್ ಆದರೂ ಎಕ್ಸಾಮಿನ್ ಮಾಡಬೇಕಿತ್ತು.
Hospital. They have published before the JMFC in the criminal case. I have obtained the certificate copy from the JMFC of good certificate and the FIR not surrender. I have produced the same before the tribunal. If I collected the good certificate from the doctor,
you should.
ನಾನು ಅದನ್ನ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ, of course it's my mistake. I have not obtained the signature of the doctor.
Hello.
What is duty of the prosecution? Why they are producing the certificate of the injured before the JMS?
This I would have been in a position to appreciate if I were to be hearing some criminal revision arising from that case regarding the validity of the trial held or the appreciation of evidence. I am not appreciating the criminal case. When will you produce?
From the hospital,
ಮತ್ತೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು, ಎಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ಗೆ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಬೇಕು, ಎಲ್ಲ ಮಾಡಬೇಕು. ಆಯ್ತು. ಶ್ರೀ NR ರವಿಕುಮಾರ್, learned counsel for the appellant. Praise time. ಎಷ್ಟು ಟೈಮ್ ಬೇಕು? 2 weeks. ಬಟ್ ಇದೆಲ್ಲ ನೀವು
the injury, he has sustained the injury. My name is displayed in the police notice, FIR and other police document. I have produced the same before the tribunal. The wound certificate obtained by the police from the doctor and same has been placed before the JMC. I have obtained the certificate copy from the JMC and same has been produced before the tribunal.
In this kind of cases where bus passengers are injured, so if some 8 are injured, some 8, 9 are others are also included. This is their grievance, insurance companies. So therefore, we must scrutinize some minimum evidence. We should expect minimum standard of evidence. Yes, next 2 weeks. Next. Manjunath Patan Shetty.
I appear for respondent, my lord. Insurance appeal, my lord.
What is the vehicle? What is the vehicle? Tractor.
In the lands of the states, the driver came and hunting down, and because of the injury sustained, the heir succumbed to the injuries.
Heir was driving it.
Not the heir. Heir had engaged somebody to drive the tractor. Right? Came and dashed the heir. Because of the injury sustained, heir succumbed to the injuries. The contention of the insurance company is the tribunal has not lived with the contention of the insurance company. The reason, nowhere it is mentioned in the claim records that the vehicle was taken for hire. You are not fine.
Now you wanted time, is it?
Yes,
why?
Do some research on because it's altogether a new point because section 2 already has been referred to. Gives a definition of owner vehicles. In which even higher person who is in a position of the vehicle on a higher purchase agreement also treated as a owner. So it is a specific contention of the insurance company that he would step into the shoes of the owner. Such business is not true.
Learned counsel for the appellant. He has recently filed wakalat for the appellant on account of the death of the previous learned counsel, and she wants to do research on the case law relating to section 2 within bracket 30 bracket close of MV Act 1988. It is after 2 weeks.
On submission, my lord. On submission, my lordship, two accident is a 2008, my lord. Lordship, kindly fix the date.
Date will be there. New website ನಲ್ಲಿ ನೋಡಬಹುದು. Date ಇರುತ್ತೆ.
Oblige.
64, O Mahesh.
Here for the appellant.
ಯಾರು ಲಾಯರ್ಸ್ ನೆಟ್ ಅಂದ್ರೆ ಆಗಲೂ ಇತ್ತಲ್ಲ ಅವ್ರದ್ದು ಅಲ್ಲಪ್ಪ ಆರ್ ಚಂದ್ರಶೇಖರ್ ಅಂತ ಇತ್ತು. What is the point, Mr. Mahesh?
But this is a self-accident, my lord. There was a delay of 56 days delay
in lodging the complaint.
Lodging the complaint. And the deceased, my lord, was under the influence of alcohol. He went and dashed against the, my lord, the lorry which was going ahead of him.
The Ranne Tribunal has dealt with this drunken driving.
Charge sheet, my lord, was against him.
Against the deceased.
Deceased, my lord, under the influence of alcohol.
Charge sheet is against the deceased himself.
Deceased himself, my lord.
Deceased himself.
Yes.
Then what is the reasoning of the Ranne Tribunal for allowing the claim petition filed by?
It is, my lord, it is, my lord, and section 163A. May I state the facts, my lord? This is, my lord, one Arif Khan, aged about 38 years, doing steel business, contending, my lord, 40,000 per annum. Accident, my lord, is of 2006. Because it was for his own negligence, they thought of, my lord, making a claim under 163A, reducing the, my lord, the income artificially to 40,000. Date of accident, my lord, is 5/7/2006 at 9 p.m. Deceased, my lord, was driving a Santro car bearing registration number A1 MA 8723. Insured, my lord, one Srimati Vasimunisa placed ex parte after service of notice. R2, my lord, the appellant before lordship contested, saying that the deceased was intoxicated, had no driving license. Charge sheet was against him for his own negligence and cannot bring the claim petition under 163A, though he does not come under the, my lord, the category of the section of, my lord, society whose income does not exceed 40,000. 163A, my lord, specifically a structured formula meant for, my lord, the section of the society whose income does not exceed 40,000 per annum. Accident, my lord, is of 2006. Deceased, my lord, was stated to doing steel business, my lord.
1 minute.
And it is unimaginable, my lord, his income is only 40,000 per annum.
In the claim petition, he has stated that his income, he has stated his income anywhere?
Claim petition, my lord, they are restricted to 40,000 rupees. You will have to kindly turn to, my lord, the claim petition. But what I am trying to canvass before lordship is an accident of 2006, my lord. If a claim petition were to be in the normal, my lord, the course under section 166, in absence of proof of income of the, my lord, deceased or injured, Lok Adalat chart is taken into consideration, my lord. But then the income would be, my lord, more than 40,000 per annum.
Or 2006, have they fixed any?
The old cases, they are not fixed, my lord. 2008, my lord. My lord, you will have to kindly see. He had a passport, my lord, exhibit P17.
P17 is passport.
That itself would show doing a steel business, my lord, admittedly, would be earning more than 40,000 per annum. With the ulterior motive, my lord, it is restricted to 40,000 to make a claim under section 163A.
So, ಅವರು ಆರ್ ಚಂದ್ರಶೇಖರ್ ಅವರು ಬಂದಿಲ್ಲ. Your argument has certain facets which has seemingly not been considered. I don't know whether there are any decisions dealing with this. If somebody restricts his higher income only to accommodate himself within 163A, could it be said that tribunal had no jurisdiction to entertain such a petition? This is the sum and substance of your contention.
May make one submission, my lord. At this point of time, my lord. They can't, my lord, restrict their income, though they are having,
I follow.
my lord.
No, I follow your argument. I follow it is quite interesting.
That's why I pointed out to exhibit P17, my lord, having a passport.
And in fact, you see the claim petition. He doesn't, make any bones about it. He says his income is more than 15,000 per month, and he is an IT SSC. He states that. So it's an interesting point you are canvassing. Some research also is required. Is there any case law on that already traversing this very aspect? And I have some reason to believe that this would have been dealt with by some decision. Some research is required. And that your opponent, learned opponent, is also not here. It's an undoubtedly interesting aspect. What you are saying is the object is to cater to a particular segment. And anybody and everybody cannot accommodate themselves by saying, okay, I have a higher income, I don't have proof, therefore let me consider under that category, special category. You say it is impermissible because it defeats the legislative object. That is your submission. I don't know why you are not on the video. Only your audio is very clear, very audible, very clear. But you are not on video. Doesn't matter.
Also there, my lord. Video is also there.
That is. I am on your video, but you are not on my video. Doesn't matter. Doesn't matter. I understand the amplitude of your argument. I have understood that. But my only this thing is, since this motor vehicle accident litigation is very active since the last 40 years, so there would be some decisions. Some research is required before we delve into that.
My knowledge, my lord, this point which I have canvassed, my lord, is not, my lord, dealt by any judgment, my lord.
But I want to be sure of that.
If my learned friend, my lord, appearing for the claimant could enlighten, my lord, that would be.
No, he is not only not on my video, he is not also on my audio radar. How can I ask him? I don't
Makes
know.
a physical appearance, my lord. That's why I.
That would be very nice. So I am constrained to put it off. In the meanwhile, there is a change in the roster also. I was, ಇದು ಒಂಥರ ಹಳೇದನ್ನೆಲ್ಲ ಎಲ್ಲ ಆರ್ಗನೈಸ್ ಮಾಡಿ ಆಯ್ತು ಏನೋ ಮಾಡಿ roster change in the roster is not a problem. It is good.
All these old matters, my lord, are being.
It is good only. I am not unhappy about it. New subject, instead of getting confined to one subject only, it is good to have different subjects. Really challenging. So I put it off by 1 week, and you can also do a thorough research job. You want a little more time?
I'm very clear about that, my lord. No decisions, my lord, deal with this submission which I have made before your lordship. Because it's a social piece of legislation.
No, you don't. I mean, you don't have to further elaborate on that. I have comprehended your exact submission. It is also interesting. I can't deny that. It is interesting. It is
My
like
only concern, my lord.
It is like put it in another context. There is this OBC reservations. Now everybody wants to squeeze into that.
That's what, my lord. I just wanted to put it in other way. Whether we are going to make the, my lord, population dishonest for the purpose of, my lord, from material.
Instead of as one would expect a competition to be on the forefront, now the competition is to be on the backbench. So the another facet of that is, even though I should be proud, I am working and earning a little higher income, I have no compunction in saying that I have lesser income. No, everybody getting, that benefit for a seat in the engineering college, low income, this thing. This is one part of our weakness in our society.
But my respectful submission, my lord, sympathy, my lord, of the court is being misused.
On this, I don't have any sympathy. Only thing is, courts have been doing it by way of some kind of practice that thousands of 163A cases are permitted to be filed, entertained, allowed on the basis he has reduced his income, fine. He can bring himself within the net of 163A. This has been the approach. Now, to take a different this thing, I should be sure by way of some research, definitive research, that courts have not pronounced on this question so far. If they have pronounced, then I should have the benefit of looking into that and taking my own views. I don't flinch from that. I will take my own view, but I should be sure that no court has touched this subject at all. If they have touched, I should be having those decisions.
But my request is only your lordship can lay down the foundation stone for this. As to my knowledge, my lord, there is no ruling touching upon this point.
ಮಿಸ್ಟರ್ ಎನಿವೆ ಅವರು ಇಂಥದ ಇರುವ ಕಾರಣ ಅವರನ್ನು ಹೇರ್ ಮಾಡಬೇಕು. Mr.
He has to be heard, my lord. I have no.
Pius Net and R. Chandrasekhar. Learned counsel for R1 to R4 is absent. Learned counsel Sri O. Mahesh for appellants in both the appeals is present. His submission is that even though in the claim petition, the income of the deceased allowed, no?
Deceased, my lord.
In income of the deceased is stated to be more than rupees 15,000 per month, and he is stated to be an IT assessee having passport as per Exhibit P70, the claimants have, in order to make a claim under Section 163A of the MV Act 1988, restricted the income of the deceased to rupees 40,000 per annum. Full stop. The submission of the learned counsel is this amounts to adopting a device for claiming compensation under 163A, which is in the very nature of thing meant for providing some succor to certain segments of society, namely those who have income less than 40,000 per annum. Full stop. His submission is that the liability is based on the insurance company without it being able to question negligence on the part of the driver of the insured, and therefore by means of a device of this nature, people whose income is demonstrably more than 40,000 per annum should not be permitted to make their claims under Section 163A, which is founded on no fault liability, and consequently insurance company is not able to question its liability to indemnify the compensation. Stop. Since the learned counsel, full stop. Next for Sri O. Mahesh, learned counsel submits that the availability of the provision under Section 163A for even those whose income is more than rupees 40,000 per annum has not been examined by any court in this country. And therefore, it requires a detailed consideration. Stop. Since learned counsel for R1 to R4 is absent, list these appeals next week. Then pass over na ಮಾಡ್ಕೊಂಡು ಇನ್ನು ಹೋಗ್ಬಾರಿಲ್ಲ ಯಾರು ಬರೋದು ಇನ್ನು Mr. Mahesh?
Yes, madam.
This Workmen Compensation Act You are questioning liability or quantum?
On the mainly, my lord, on question of liability, my lord. Because, my lord, in the connected claim, my lord, the claim was rejected. And that is not challenged. And in this case, my lord, the deceased was traveling, my lord, on the hook. That is, my lord, the tractor hooked to the, my lord, trailer. You are neither, my lord, on the tractor, nor, my lord, in the trailer. It's a agricultural, my lord, package policy.
You know, you are ready.
And this vehicle was, my lord, taken on hire, admittedly.
Learned counsel, some ಹೆಸರೇನು for Srimati Kavita HC, for Miss Kavita HC for R1 to R5 submits that his learned counsel is held up in some other court, at least next week.
Chandrasekhar Reddy. Suresh Amlatur.
ಏನಿದು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಗೆ ಹಾಕಿದ್ದ? ಡಿಸ್ಮಿಸ್. ಆಯ್ತು, ಅದು ಬರ್ತಾನೆ ಇರ್ತದೆ. ಈ ಫ್ಯಾಕ್ಟ್ ಏನು ಅಂತ ಹೇಳ್ಬೇಕು ಬರುತ್ತೆ ಅದನ್ನು.
Another person was on the way. Let me take his car. And get away and 166 of the crack.
There are two claimants. One is Narayan Swami, another Chand Pasha. Chand Pasha is the driver. Charge sheet is against him. ಇದೇನು ಇದು ಆಕ್ಟ್ ಪಾಲಿಸಿನಾ? ಓಕೆ.
Income as a driver. In the class examination also he said income is 6,000 rupees. And he paid the repetition. He successed the repetition.
Repetition is filed for what purpose?
For rejection of heir.
Oh, conversion was rejected.
Till that he said my income is 6,000 rupees. Any person can withdraw his income after that. Right? That's rejected. Basically, lately the case is on merits. He better read there.
ಅದಂದ್ರೆ ಅದು ಇಂಟರ್ಲಾಕ್ಯುಟರಿ ಸ್ಟೇಜ್ ನಲ್ಲಿ ಅಲ್ಲ, ಇದು MACT ಡಿಸೈಡ್ ಮಾಡಿದ ಮೇಲೆ ಹಾಕಿದ್ದಲ್ಲ. ಇದರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? ಇರಿ ಇದರಲ್ಲಿ ಇದೆ ಅಂದ್ರೆ ನಮ್ ಪುನಃ ಅಲ್ಲಿ ಫೈಲ್ ನಲ್ಲಿ ಇದೆಯಾ?
You have to know that. Not maintainable.
These appeals are at the instance of Nayan Swami and Chand Pasha. Both filed application. 163 ಮಾಡಬೇಕು. ಈಗ they have not made this the owner and insurer of the car as party. Tribunal has also on the rash and negligent driving. What is the finding of the tribunal?
was driving as a gaseous person in the car. Because pillion is supposed that he was alone was driving the car, and he saw Pillion Narayana Petkura, so he asked him to come to his car. So in this way, Pillion was driving in the car. He was traveling in the opposite car, go down to Bangalore, go to Mumbai, on to Chan Pasha. The opposite car came to the opposite direction, next to his car. So this accident is sustained in injury, was shifted to Westwood Hospital. He said that he did not know the criminal case filed against him. One. Further, he stated that he did not know the lorry driver has filed a complaint against his car driver. Till then, we denied the accident due to rash negligence driving the car into one. Car 11, page 11 of Tribunal. So this is the exhibit P1. First input should exhibit P1 is made by Devraj. He has alleged that on the date of the accident, the lorry in his car was just behind the lorry when the air is it is alleged that this lorry belonged to the law. It is further alleged that when the lorry came to the accident gate, the time car came to the opposite direction, next speed, in a rash negligent manner, against the lorry. So we alleged that the car came in rash speed and in a rash negligent manner caused the accident. There is no counter complaint to one. We admit that they are not challenged the charge sheet. The first input report by this game. Evidence on record makes it clear that no fault on the part of the lorry driver. So the negligence is on the part of the one which cannot get the part of the lorry driver accident has taken place. The complaint is filed against the
Enough. Work well.
My lord, I am the appellant in this case.
Yes.
Here, my lord, in this case, my submission that the tribunal has dismissed the claim petition without any evidence against the driver of the car, my lord. I am submitting that there is no evidence from the respondent side to show that there is any negligence on the part. The only criminal case, that is the charge sheet, and giving the finding with regard to the rash and negligent driving of the car driver is wrong, Your Honor. Therefore, I have produced the number of decisions. There are about 4-5 decisions have been produced for this honorable court. I have given the copy to the other side also. In all these decisions, the Honorable Supreme Court, Honorable Supreme Court has laid down the
charge sheet was produced or not produced?
Yes, produced, my lord. Charge sheet is produced.
Which is the charge sheet? Exhibit.
Charge sheet is on produced by the. No, my lord. We have admitted that the charge sheet is against the car driver, my lord, because our this one case. Therefore, we have not produced that the charge sheet. I have produced the FIR and the Panchanama. Only 2 documents have been produced. Criminal case documents.
But you admit that charge sheet is against Chand Pasha.
Yes, my lord, I admit it, and it has been admitted by the petitioners also. But here, my lord, there is a clear evidence that the PW1 and PW2, who are the eyewitnesses to the accident, no other eyewitness have been examined before the court, my lord. The evidence laid before the court is to be relied upon. The criminal case documents are not cannot be relied upon because, my lord, they have not been proved. Nobody has been examined. Complainant has not been examined, even though driver of the complainant has filed a complaint before the police. That driver has not been examined before the court, my lord. Even any eyewitnesses have not been examined by the respondents to show that there is a negligence on the part of the car driver. But there is an evidence of the car driver and also the occupant of the car, my lord. There are PW1 and PW2 who have clearly given the evidence before the court that the accident has been taken place due to the rash and negligent driving of the lorry driver. So, my lord, there is no evidence. So, in this case, Honorable Supreme Court 2013 ACJ 2544, the similar facts of the case are involved in this case also. I have produced before the court, my lord. Here also the truck and lorry, the car and truck have collided, and the police have charged it against both the persons, the car, deceased driver of the car and also the lorry driver. But the Honorable Supreme Court held that there is no evidence against the car driver, against the deceased car driver. Therefore, the lorry is solely responsible for the accident, my lord. In this case, the Honorable Supreme Court held that. And also there is a decision of the Supreme Court, the 2014 ACJ 2550, wherein it is held that without any evidence, either corroborative or oral evidence, direct evidence, finding cannot be given with regard to the negligence.
Yes.
My lord. My lord, there is a decision. May I read the decision of Supreme Court? 2014 ACJ 2550 Supreme Court. Page number 6, my lord, where I have given that. In that decision also, the Honorable Supreme Court, referring the decision of the Kuruvilla case, my lord, has given the law has been laid down here, para number 11 of the decision. Para number 13, I'm sorry, my lord, para number 13 of the decision. With regard to the appellant father, here there is a collision between the motorcycle and the tractor, my lord. The middle of the road, the Honorable Tribunal has given the finding that there is a 50% negligence on the part of the motorcycle rider. But there was no evidence from the respondent side. Therefore, the Honorable Supreme Court set aside the finding of the Tribunal and also the High Court and held that there is no evidence against the driver of the motorcycle, rider of the motorcycle, Your Honor. Here, I will read the para number 13 of the decision.
Yes.
So, with regard to the apportionment of contributory negligence at 25% on the part of the appellant father and 75% on the driver of the offending tractor, as determined by the High Court, we refer to the judgment of this court in Jiju Kuruvilla versus Kunjuvanna Mohan, 2013 ACJ 2141, Supreme Court, as it is applicable to facts of the case on hand. In the above case, Joy Kuruvilla had a head-on collision with a bus approaching from the opposite side. Joy Kuruvilla sustained serious injuries and died on the way to hospital. The tribunal found that the accident occurred due to rash and negligent driving of the bus driver. It apportioned the contributory negligence between the driver and the deceased in ratio of 75-25 on the basis of pleadings and evidence on record. In the above said case, this court has held thus on the negligence of the driver of the bus. The mere possession of the vehicles after accident, as shown in the scene of Mahajar, cannot give a substantial proof as to the rash and negligent driving on the part of one or the other. When two vehicles coming from opposite directions collide, the position of the vehicles, their direction, etc., depends on a number of factors like the speed of vehicles, intensity of collision, region for collision, place at which one vehicle hit the other, etc. From the scene of the accident, one may suggest or presume the manner in which the accident occurred. But in absence of any direct or corroborative evidence, no conclusion can be drawn as to whether there was a negligence on the part of the driver. In the absence of such a direct or corroborative evidence, court cannot give any specific finding about negligence on the part of any individual. Postmortem report exhibit A5 shows the condition of the deceased at the time of death. The said report reflects that the deceased had already taken meal and his stomach was half full and contained rice, vegetables, and meat pieces in a fluid with strong smell of spirit. The aforesaid evidence, Exhibit A5, clearly suggests that deceased had taken liquor, but on the basis of same, no definite finding can be given that the deceased was driving the car rashly and negligently at the time of accident. The mere suspicion based on the scene Mahajar, Exhibit B2, and the post-mortem report, Exhibit A5, cannot take the place of evidence, particularly when the direct evidence like independent eyewitness, PW3, FIR, Exhibit A1, charge sheet, Exhibit 4, FIR statement, Exhibit B1 are on record. The observations here, it is an important, my lord. The observations made by this court in the case of Jiju Kurvila surely applied to the facts on hand. Upon thorough examination of the facts and legal evidence on record, in the present case, it cannot be said that the appellant father was rash and negligent just on the assumption made by the tribunal that the collision occurred in the middle of the road. Since the two vehicles were approaching from the opposite directions of the road, however, the only aspect of the case on hand that we can reasonably assume is that appellant father would have taken a sufficient caution while riding the motorcycle since he was traveling with his two minor children, appellant minors. Further, upon examining the evidence produced on record, there is no proof showing negligence on the part of the appellant father. Thus, in our view, the contributory negligence apportioned by the High Court at 25% on the appellant father and 75% on the driver of the offending tractor is erroneous, keeping in view the legal principles laid down by this court on this aspect in the above referred case. Thus, we are of the we have firm conclusion that negligence is wholly on the part of the driver of the offending tractor since he was driving the heavier vehicle. Therefore, we set aside the 25% contributory negligence on the part of the appellant father as apportioned by the High Court, my lord. Here in this case, there is no evidence against the father of the rider of the motorcycle, my lord. Therefore, the contributory negligence held by the tribunal and the High Court has been set aside. And here, my lord, there is another decision of Supreme Court 2014, ACC 627. The next decision, my lord. Page number 12.
Not necessary.
My lord, here.
And the decisions act not noted.
Without
you see, the complaint is by not by lorry driver, not by you. It is by another person who are driving his car just behind the lorry. Your car hit the lorry from behind.
No. There is a collision but opposite direction. Collision, opposite direction collision it is. It is a collision from opposite direction. That here, my lord, he was behind the lorry, so he could not have seen that accident, my lord. He cannot be an eyewitness. The person who is the complainant who was behind the lorry, he cannot be an eyewitness because he could not have seen the accident. How the accident took place. But on the basis of the complaint given by that person, the charge sheet has been filed by the police.
ಎದುರುಗಡೆಯಿಂದ ಅಂದರೆ ಕೋಲಾರ ಕಡೆಯಿಂದ ಬಂದಂತ ಅತಿ ವೇಗ ಲಾರಿಯ ಬಲಭಾಗದ ಚಕ್ರಕ್ಕೆ ಡಿಕ್ಕಿ ಹೊಡೆದ. ಹಿಂದಿನಿಂದ ಬರ್ತಿದ್ವಿ.
He cannot see. He could not have seen that accident at all, my lord. The person who has not seen the accident has given, he is a relative, he is a brother-in-law of the lorry owner, my lord. That the complainant is the brother-in-law of lorry owner.
ಅದಲ್ಲ ಈಗ ನೆಗ್ಲಿಜೆನ್ಸಿನ ವಿಚಾರದಲ್ಲಿ 163A we are on that, not on that. ಅದನ್ನ ಅವರು ಹೇಳ್ತಾ ಇಲ್ಲ, ಅವರು ಹೇಳೋದು ನೆಗ್ಲಿಜೆನ್ಸ್ ವಿಚಾರದಲ್ಲಿ.
Yes, my lord. Previously
163A ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ. ಆಯ್ತು.
in that first decision also the facts, similar facts in this case, Your Honor. 2013 SCJ 2544, wherein the truck and car has been collided in both the cases. The police have charged it against both the persons. But there, Your Honor, my lord, that the deceased was a car driver in that
It
case.
is not correct. 2544 ನಲ್ಲಿ ಇಬ್ರು ಡ್ರೈವರ್ ಮೇಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು.
ಹೌದು ಸರ್, ಹೌದು.
It is not, ನೀವು ಯಾವುದೋ ಬೇರೆ
Point of the court that on the basis of evidence only, my lord. Therefore, here the respondents have not led any evidence. Neither the driver of the lorry nor any eyewitnesses by the respondents to show that there is a negligence on the part of the car driver, my lord. So when there is no evidence against the car driver with regard to the negligence, that cannot be a given finding, negligence.
These appeals are at the instance of the claimant calling in question the correctness of the judgment and award dated 22/4/2010 in MVC number 2150 and 2151 of 2008 for so and so. The claim petitions were filed on the allegation that on 17/11/2007 at about 7:20 p.m. when the claimants were traveling in the car carrying registration number K01P3595 from Kolar towards Bangalore, near Chikkanhalli Gate, Nandagudi, Hubli, a lorry bearing registration number KA262350 came from the opposite direction in high speed and in a rash and negligent manner and they dashed against the car, resulting in grievous injuries to the claimants. Next paragraph. For the learned tribunal, claimants had made only the owner and insurer of the lorry bearing registration number K262350 as respondents. The owner and insurer of the car in question were not parties to the proceedings before the learned MSc. Respondent number 1, the owner of the lorry remained ex parte. Insurance company contested the proceeding by filing written statement. It is stated therein that the police had charge sheeted the claimant Jan Pasha, who was the driver of the car. Next paragraph. During the trial, claimants examined themselves as PW1 and PW2, and one doctor was examined as PW3, and an official from Hosmat Hospital was examined as PW4. Exhibit P1 to P19 were marked. Next. Sorry, respondents did not examine any witnesses and no documents were marked. Next paragraph. After hearing the learned counsel on both sides and perusing the records, learned MACT dismissed the claim petition. Next paragraph. Learned counsel for the appellant claimant strongly contends that even though the charge sheet is against the claimant appellant Chand Pasha, both the claimants have examined themselves and they are eyewitnesses, and they have stated very clearly that the accident had occurred only on account of the rash and negligent driving of the lorry in question by its driver. And in spite of the same, the tribunal has held that the accident occurred only on account of the rash and negligent driving of the claimant Chand Pasha, even though the driver of the lorry was not examined before the tribunal. He therefore submitted that the appeal is entitled to be allowed and the matter remanded to the learned MACT for fresh consideration. Next paragraph. Learned counsel for the respondent insurance company per contra contended that the claimants did not make the owner and insurer of the car in question as respondents before the learned MACT. A full stop. He submitted that admittedly the charge sheet is filed against the claimant Chand Pasha. The evidence of PW1 and PW2 are self-serving version, and in the absence of the claimants examining any independent witness to support their case, learned tribunal was right and justified in dismissing the claim petition. He therefore contended that there is no merit in the appeals and they are liable to be dismissed. Next part. I have given my anxious consideration to the submissions made on our both sides, and I have carefully perused the records. The admitted position is that charge sheet was filed against claimant Chand Pasha, who was driving the car in question at the time of the accident. Full stop. In spite of the same, the claimants have not chosen to make the insured owner and the insurer of the car of which claimant Chand Pasha was the driver and another claimant was an insured. Full stop. Learned tribunal, which had the opportunity of recording the evidence of the claimant, after detailed consideration of the evidence, has held that the accident has taken place only on account of the rash and negligent driving of the car in question by claimant Chand Pasha. full stop. The claimants have not made the owner and the insurer of the car in question as respondents in the claim proceeding. Full stop. Learned, after appreciating the evidence placed before the learned tribunal, I am of the view that no fault can be found with the finding of the learned tribunal regarding negligence, as the version of PW1 and PW2 are necessarily self-serving, and the charge sheet is against claimant Chan Pasha himself, and claimants who have the onus of showing that the driver of the lorry was negligent has not examined any independent witnesses to establish the said fact. Therefore, there is no error or illegality in the finding recorded by the learned tribunal that the accident had taken place only on account of the rash and negligent driving of the car in question by claimant Chan Pasha. A full stop. Accordingly, there is no merit in the appeal, and it is there is no merit in these appeals, and they are liable to be dismissed. And the above appeals are dismissed.
Nam decision is follow my refer
ಎಲ್ಲ they are on facts. They are ಎರಡರ ಮೇಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾನೆಲ್ಲ ಓದ್ತಾ ಇದ್ದೇನೆ ನೀವು. ಏನು
ಕೇಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ರಿಲೈ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅದೆಷ್ಟು.
is perfect. Just again.